Recording in progress. Recording stopped.
Ito lang yan. Kailangan po, kita naman yung zon, kaya yung niya po sa SAPS.
Recording in progress.
Good morning, everybody. I saw the minister on the platform. Good morning, Minister.
Morning, Chair. Morning, the members.
Good morning, GM.
Morning, Chair,
Morning,
and
Minister.
good morning, Minister and members.
Good morning, General, National Commissioner. I see the National Commissioner here.
Good morning, Honorable Chairperson and Honorable members. Good morning, Minister. Good morning, DM. Thank you, Chair.
Thanks very much. Good morning, Acting Secretary.
Good morning, Honorable Chair, Honorable Members, Minister, DM, National Commission, and colleagues. Morning.
Good morning to you all members. I see Honorable Whitfield, Honorable Marekwa, Honorable Mulekwa, Honorable Terplanch, Honorable Peacock, good morning to you all.
Molweni nonke.
Thanks very much.
Morning,
Let's start with.
Chairperson.
Thank you.
Good morning, Chair.
Good morning. Let's start with our meeting. Babalwa Winkora.
Good morning, yes, Chair.
Thank you. Can we fly to the agenda? Can I request, there is the agenda, adoption of the agenda item 1, 2, apologies, 3, opening remarks by the chairperson, 4, adoption of minutes, 4.1, 5, matters arising, 6, presentation by civilian secretariat, 6.1, 6.2, briefing by SAPS on human resource management. 7, discussion, closing. Can I get a mover for the adoption of the agenda?
Good morning, Chair. I move for the adoption of the agenda.
Thank you, Honorable Pico. Can I get a seconder?
Morning, Chairperson. I second. Gerike.
Honorable Gerike, thank you very much. Welcome.
Thank you, Chair.
Is there an opposing view? Nothing. The agenda stands as it is. It's adopted. It will guide our meeting. Can we go to item 2? Apologies.
Chair, I received an apology from Dr. Groenewald. That's the only apology I received.
Thank you, Babaloa. I got a message from Honorable Gomba that she will be joining the meeting at 10. She's in transit. Any other apology from the platform? Thank you. Let's move to item 3. Honorable members, last week we welcomed Honorable Madala Masuku as a newly appointed member of the committee representing the African National Congress. He was unfortunately unable to join the meeting on Friday. Let me once more welcome him to the committee and ask if he is in for today. Is he in, Babalo?
No, Chair.
Okay. Honorable members, on Friday, we resolved to continue clause-by-clause deliberations today and requested the department to revisit clause 4 on the appointment of the executive director, taking into account the McBride judgment, comments raised by members, and the drafted private members' bill of Honorable Whitfield. I've read through the Constitutional Court judgment on the matter between McBride versus the Minister of Police once more. Paragraph 31 of the judgment states, and I quote, "What then does the independence of IPID mean? Does it mean complete or sufficient independence? Admittedly, it is difficult to attempt to define the precise contours of a concept as elastic as this. It requires a careful examination of a wide range of facts to determine this question. Amongst this are the method of appointment, the method of reporting, disciplinary proceedings, and method of removal of the executive director from office, and security of tenure." Close quote. The Constitutional Court highlighted the method of appointing and removal from office of the IPID executive director as 2 key tests and indicators for the operational and structural independence of IPID. We must find common ground on the level of parliamentary involvement in the appointment process. I think it is safe to say that we will not find full consensus on this aspect of the bill, but we must strive towards a middle ground. As I stated from the start, we must harmonize the divergent views of the public and committee members. In line with the constitutional judgment, the revised bill addresses deficiencies in the method of appointment, the method of reporting disciplinary proceedings, and security of tenure. I'm certain that the version we have created as a committee will pass the constitutional muster. We are on course to finalize the bill on the 29th November, a week later than planned. But as I stated earlier, further clause-by-clause deliberations were needed. That's why we're here today. Honorable members, immediately after we are done with clause-by-clause, we'll then receive a presentation from SAPS on their human resource matters. Members in one meeting requested that SAPS come and brief this committee on their structure, as well as other related human resource matters. That is why, if you check today, we have penciled the meeting from 9 to 14 hours. Honorable members, I'm informed that the Minister intends releasing crime statistics on Friday. I've requested the office to apply for a special meeting on Friday, which will start. My request was from 8 to 9:30. But this morning, I also received another request from the Minister that we start at 8:30 to allow the Minister to brief the committee before the statistics can be released to the general public. May we have fruitful engagements, honorable members, during today's meeting. We then move to the next agenda item, which is item 4.1, consideration and adoption of the minutes of the previous meetings held on 8th and 10th November 2023. Can we have the minutes of the 8th, Babalo? Can you start from the top? Can we start from the top? These are the minutes of the 10th. Ne? Okay, let's continue. Adoption of the agenda. Apologies and attendance. Let's scroll down. Opening and welcome. Opening remarks by the chairperson. Civilian Secretariat for Police Services. Committee deliberations. Committee resolution. Clause by clause deliberations will continue on Wednesday, 15th, which is today. The CSPS should consider the different approaches for the appointment of Executive Director and explain which is more closely aligned with the Constitutional Court judgment in McBride v. Minister of Police. The legal advisor should collect all relevant information that were made in the McBride judgment pertaining to the appointment of Executive Director so that the committee can have all information at its disposal. The content advisor and CPS should work together to align all the views. CPS should provide rationale for the inclusion or exclusion of certain amendments, such as constitution of the panel to appoint. Closing remarks by the chairperson and the meeting adjourned at 10. Can I get a mover for the adoption?
Chairperson.
Honorable Gerike.
Can I just ask a question before we move?
Yes.
I just want to understand the sequence of the minutes, and I mean there were a lot of deliberations and party positions and so on. Is that not reflected in the minutes? Because I didn't see it in both the minutes, the positions of the party and this which we have expressed. We only see, the community. I mean, the different department within the department, their views and so on. Where do our views and the party's positions reflect? How do we do that?
If there is an amendment, Honorable Gerike suggests that amendment in the in the deliberations, that's where members put their views. And if your view is not represented, suggest that amendment so that we correct the minutes.
Yes, that is exactly what I'm asking. Thank you for assisting me. Let us then request the committee, personnel or secretariat to include the views of our parties, not necessarily the individual views, but the views that we have put. Remember that you have said that we must work, or the culture is that we work on a consensus basis. So we work together, but we want our views to be reflected. That's all I'm asking, Chairperson. We have made a lot of positions, submissions, and we've stated our positions and so on, not only the EFF and other parties, also the ANC as well. And I think it's fair if it's reflected within. And there's no specific amendment that I want to make at the moment, but there's a record of what has been discussed, and therefore the record should speak.
Okay. The input is that the Secretariat should consider including the views that were presented when members were deliberating, and that will be done. The Secretariat will go back to their archives and check whether there's something that they've missed. Can we adopt with that understanding?
Chair, my hand is up.
Honorable Whitfield.
Thanks very much. Chairperson, it's an interesting point that's been raised. It's never in the history of this committee been that individual political parties are cited in the minutes. However, if you look at the way the minutes are structured, it refers to members. Members raised a particular point, or members made the following point, and that may refer to one individual member. And so I think that if members want their views to be recorded, then they must bring amendments if those views are missing. I don't think it's helpful to make a general point, but rather to say, I raised the following point, please include it. And I think that's the way we should proceed. Political parties, as I recall, are not specifically cited in the minutes. It would refer to, for example, Honorable Gericke made the following point, or as you see in the minutes, Mr. Whitfield made the following point about the private members bill. Members agreed on the following points. I don't know that there's a need to change that, but when members want to include points that they had made, which they feel are omitted, they must then make amendments. That is how the minutes work, and I think have always worked.
Thank you, Honorable Whitfield. Honorable Shigima.
Yeah, thank you very much, Chairperson. Yes, I think I must agree with the Honorable Whitfield, because then it simply means that, unless, of course, members specifically want their names to be mentioned there, otherwise you're going to find that every little contribution that we made is expected to be on the minutes, and it's going to be become tedious and quite an issue. So I want to support Honorable Whitfield. If members want it to be mentioned their names and what they contributed, then indeed we must do that. But we'll be setting a precedent, because I can tell you that, and all members are eventually going to want whatever contributions they make put into the minutes as well. Thank you.
Thank you, Honorable Gericke.
Yeah, Chairperson, I want to say that when we discuss matters now, let us discuss on a factual and rational basis, not on, what happened in the past and that cannot be changed and so on. I am not advocating for each and every time when I speak that my name should be included. I'm advocating to say, for instance, if a party or if myself as a member has submitted a critical issue, for instance, the debate that I had around the separation of powers and so on. That is a critical debate in the flow of this business. It's not necessarily a proposal because I bring it in the context of the committee. Nobody in the committee objects to that, but that we say that this point has been raised by the EFF or the DA or the ANC or whatever, and therefore this is for further deliberations. I don't see it there. Although you have said this, when I raised the point, you said it's for further deliberations on a couple of points that I've raised. I'm just merely saying we must have record of what we have said in that meeting and the resolutions that we have taken. That's all. We cannot just have a general outline of the minutes. It's not the true reflection. Yes. Did you interject me, Chair?
Honorable Gerike.
Yes.
I called for you to submit any amendment that you think is not covered here so that we are able to move forward. We are members of the committee, yes, representing different political parties, but it becomes difficult if you don't point us to a contribution that you have made that was missed by the minutes.
Okay. All right. I've just given you an example, Chair, and I will move on. It's fine. I will move on. I've just given you an example. Those examples should be highlighted because it's important to the debate, to the entire debate of the creation of the bill. Thank you, Mr. Chair.
Okay. The amendment is that you include the input by Honorable Gerike on the separation of powers. Am I correct?
Yes, Chair, this is the one point. It's fine. I will go back.
All right.
You are correct, Chair.
Then Honorable Peacock.
No, Chair, I just wanted to have an input on that, but you've covered me well. And other members have also covered me well based on the issue raised by Honorable Gerike. Thank you so much.
Thank you. I don't want us to spend a lot of time on the minutes, but I want us to be satisfied that the minutes represent the discussion in that meeting. Honorable Terplanch.
Chairperson, thank you. To raise the issue that
Honorable Terplanch,
the debates on this very issue is going to follow in Parliament. So there will be, I understand that it must reflect what happened in
Honorable Terplanch is gone. Honorable Terplanch?
Was it?
Honorable Terplanch? Okay. Can I get a motion for the adoption of the minutes with that amendment as submitted by Honorable Gerike?
Yes, Chairperson, I want to second that the minute be adopted with amendment as said by Honorable Peacock. Thank you very much.
Okay. There is a motion. Is there a seconder?
I second, Chair.
Seconded. Is there an alternative view? Minutes adopted with amendments. Can we have the second set? Mabalwa?
Chairperson, I just want to say I'm back, I'm covered also, thank you.
All right. Mabalwa, can we have the second set? Minutes of the 8th November. There's the agenda. Adoption of the agenda. Apologies. Opening and welcome. Opening remarks. Let's go down. Let's go down. Matters arising. Any remarks by the Deputy Minister? Let's go down. Presentation by Civilian Secretariat, Content Advisor, Committee Deliberations. The Secretariat should provide a detailed presentation on disciplinary regulations. Committee agreed, extending the it was not extending the mandate. The committee agreed to have a way of coordinating a meeting with other relevant committees. The Secretariat should pay response to the questions posed, which was done. Closing remarks by the chairperson. Let's continue. Go up. Go up. Go up to the end, Babalo. The meeting agenda 12:15. Are there amendments to the minutes? The minutes were given to honorable members well in time. Is there any amendment? No amendment. Can I get a motion, a mover for the adoption of the minutes?
Thank you, Chairperson. I move for the adoption of the minutes.
Thank you, Honorable Mulekwa. Moving for the adoption. Any seconder?
I second, Chairperson.
Thank you, Honorable Peacock. Is there an alternative view? Minutes adopted. There is somebody with an iPad, Babalwa. Can that person identify him or herself? Otherwise, we remove that person from the platform. iPad.
Good morning. Good morning, Chairperson.
Hello.
Yes, good morning, Chairperson. It's General Musikidi. I'm still trying to find how to rectify this. I don't know how did it take my name out. Chairperson,
Okay.
I also tried to log off and log in again so that I can go to the settings. It doesn't allow me, but I will keep on trying and I will rectify. Thank you.
Thank you, General. There's another one with 53117778. Can you identify yourself?
Chair, Amadala Masuku, I'm just checking because where I am, it might be that I don't know if it's reflecting on that side my name, but I did do the necessary thing. So it might be that where I am, it might be that it doesn't show.
No, it reflects. I see Honorable Madala Masuk here, but there's another one, 53117778.
Morning, Chair. It's me. It's Nolundi. I'm using the laptop. My phone is giving me challenges.
Thank you. Maybe before even we continue, Honorable Masuku, we welcomed you on Friday. We continue to welcome you today, but unfortunately, by that time you had not joined. Can you just show your face to members and just greet them so that we continue with the meeting? Honorable Masuku.
And I think it doesn't want to give me the camera. Say, you cannot start your video because the host has disabled you. I don't know at the beginning of it.
Okay. It's fine. Let's work on that so that members can see you as a new member of this committee. Honorable members, let's move to the next item, which is presentation by presentation on clause by clause. We continue with deliberations on clause by clause, and the Secretariat will come in terms of the resolutions of the committee, the last meeting. Minister.
Yes, good morning, Chair. Good morning, honorable members, DM, National Commissioner and the team. Chair, as you say, we're continuing where we ended. Maybe it does look like it's a very long day, so maybe spending time on the matter in opening should not be one of the day. We're glad that Honorable Umatala has just joined us. I don't know why the gadget is refusing to show his face. It's not a very bad face that he cannot be shown in the gadget, but we welcome the new members, and through you, Chair, maybe it would be good that we continue with the presentation so that we save the day. Thanks, Chair.
Thank you, Honorable Minister. Can we continue, Secretariat?
Good morning once more, Honorable Chairperson, Honorable Members, Honorable Minister, and Honorable Deputy Minister. We are having a presentation that is responding on the issues that were raised last week, I think Friday. So there were two issues that we were required to come back to report on. One has to do with the issue of other equipment. If I may read, attempted matter in relation to a discharge of firearm or through the use of any weapon or instrument by a member of the South African Police, where the suggestion was whether we need to specify which are those. So the presentation will cover that. Then secondly, there was an issue around the appointment of a panel, whether it should be appointed by the committee or not. So if you allow Honorable Chairperson, Advocate Bell will take the committee through the presentation. Then you will indicate if we need to redo again the clause by clause presentation as was done last week by Mr. Milton Ndwan. Through you, Chairperson, Advocate Bell.
Good morning, Chair. Good morning, Minister. Good morning, DM, Secretary, NatCom, ED, and all colleagues on the platform. I'm going to start off with the list of weapons on slide 2. If we can go to slide 2, please. Thank you. So there was a proposal, Chair, to include a list under the definition in clause 1 that would define any weapon as contained in clause 16(1)(g) capital A. So this proposal was considered also during the public consultations. Yes, and then the department considered the proposal. However, it is recommended that providing such a list would exclude a range of objects that could potentially be used as a weapon that could injure a person or be used in attempted murder, and these would be excluded if we are going to include a closed list. It is therefore recommended that the words "any weapon" should be as broad as possible to eliminate any ambiguity or unintended consequences and not be limited by a creation of a list of weapons. Then we move on to the next slide, Chair, and this will deal with the appointment of the head of a national department. Chair, there's a regulatory framework that governs this kind of appointment, and I've just outlined it in the slide and the slides that follow. The composition of the slide of the selection committee for appointment of the head of a national department shall be chaired by the executive authority responsible for the portfolio in which the vacancy exists, and includes at least 2 other executive authorities of a national department and a national head of a department, and this is aligned to the Public Regulations 2016. Chair, this is taken out of the Executive Protocol 2020 for the appointment of DGs and DDGs. The Executive Director is appointed in terms of the Public Service Act. In terms of the Executive Protocol 2020 for appointment of DGs and DDGs, the Minister for Public Service and Administration, that is the MPSA, must be consulted by the relevant executive authority, that being the minister, on the appointment of the recommended candidate. The MPSA is further responsible for obtaining Cabinet's concurrence on this appointment. In the case of a DDG of a national department, the composition is constituted differently in that the executive authority is the chair, assisted by 2 deputy ministers and the relevant head of a department. And Chair, this is the framework that guides the appointment. And in the case of the ED, it wasn't the DDG one wasn't used. It was actually the DG protocol that was used to appoint the current DG. The current ED, sorry. If we move on to clause 4, then we are going to deal with the clauses that we were asked to expand on last week. So the proposal to provide for a panel appointed by the Portfolio Committee on Police to identify suitably qualified candidates for appointment as Executive Director is not supported. This proposal goes against the protocols provided for in the government regulatory framework on the appointment of heads of national departments. The role for such an appointment is within the purview of the minister, who is the executive authority, which differs from the appointments of persons of Chapter 9 institutions. Subsection 1 of Clause 4 has been reviewed to provide for a panel to assist the minister during this process. This is consistent with the protocols provided for in the regulatory framework for appointments of heads of national departments. Then subsection 2, Chair, provides for the relevant parliamentary committee within a period of 30 parliamentary working days of submission in terms of subsection 1 must confirm or reject such nomination. So following the debate of last week, Friday, the 10th of November 2023, on clause 4 sub 5 of the bill, a new paragraph has been added because this was taken into consideration. So there's after the 5B, we've now inserted 5C, which reads, if the position is not filled within 6 months, the minister must request the relevant parliamentary committee and the MPSA for an extension of the period, which must not exceed a further 6 months, and provide reasons for the delay. This is even going over and above what is expected of this type of instance according to the public service regulations, where it does provide for a period of 12 months without having an explanation. So here we are saying 6 months, and if need be, a further 6 months, and reasons must be provided for the delay. And this, as I said, is aligned to the public service regulations. If we can move on to the next slide, please, slide 5. So this is closed for continue, Chair. The role of the Minister as executive authority over IPID and its administration remains as contained in the Constitution and in the IPID Act. The doctrine of separation of powers must be observed. The executive authority is responsible for the supervision, performance, management, and evaluation of the executive director, and therefore it is deemed important not to be excluded from the appointment process. There are checks and balances for the oversight of the appointment of the executive director in that the provision for parliamentary involvement in the appointment of executive director has been retained as in the Principal Act, and it provides for the relevant parliamentary committee to confirm or reject the nomination. This implies, Chair, that if the parliamentary committee is not satisfied with the nomination, it can be rejected. In addition, the executive protocol provides for the MPSA to obtain cabinet's approval for such appointment. So there's a double-edged protection that we find with the appointment of the ED Chair. It is important that the process of appointment of the ED should be in accordance with the government procedures, as IPID is not a Chapter 9 institution. The proposal suggested are bringing in the practices of Chapter 9 institutions through the IPID Bill. The procedures proposed in the bill for the processes of appointment of executive director goes beyond what is recommended in the protocol mentioned above, and therefore the nominated candidate is sufficiently insulated from political interference. Slide 6, Chair, takes me to the conclusion. Then in conclusion, proposals of Honourable Whitfield are not in line with the regulatory framework for appointments of the heads of national departments, and the executive director is a public servant that falls under the provisions of the Public Service Act, Public Service Regulations, and the executive protocol for the appointment of heads of national departments. Chair, the recommendation then is that the Portfolio Committee considers and accepts the reviewed version of clause 4, 1, and 5. Thank you, Chair.
Thank you. Okay, can we have the bill? Can we have that clause? Can we present the bill?
Yes.
Can we have the, okay.
I brought it on.
Let's go to where we stopped last week. Holisani, can we move the bill to where we stopped last week?
Morning, Chairperson.
Hello, Milton.
Honourable Chair.
Yes. Hello? Milton?
Yes, Chairperson. Chairperson, the last time the committee met, we went through all the clauses. But what was happening now is that the committee was going to each and every clause to see whether they agree that that particular clause should be adopted. I think we're at clause 4.
Milton, listen. The chairperson says put the bill on the screen.
Yes.
Up to where we stopped last week, which is clause 4.
Okay. Clause 4.
Yes. Can we present the whole clause 4?
Clause 4, Chair, is the heading is the appointment, remuneration, and conditions of service of the Executive Director. Then in terms of 6.1, it says that the Minister, and A, must appoint a panel to assist the Minister to identify suitably qualified candidates for appointment as Executive Director in accordance with the procedure determined by the Minister. And then in terms of B, then the Minister must nominate a suitably qualified person and submit the name of such a person to the relevant parliamentary committee. Then in terms of step 2, then the relevant committee must, within a period of 30 parliamentary working days of a submission in terms of subsection 1, confirm or reject such nomination. And then 3, in the event of the nomination being confirmed by the relevant parliamentary committee, the Minister must appoint the nominated person as the Executive Director to head the Directorate in accordance with the responsibilities listed in Section 7 for a non-renewable period of 7 years. And then in B, the person appointed as Executive Director must, 1, be a South African citizen, and then 2, be a fit and proper person, 3, possess an appropriate qualification in law, safety and security, or of criminal justice or forensic investigation. And then in 4, must have knowledge of safety and security, the policing environment, and public admin for a cumulative period of between 8 to 10 years at senior management level, at least 3 years of which must be with an organ of state as defined in the Constitution. And then lastly, with due regard to his or her experience, this person must demonstrate high levels of conscientiousness, integrity, and commitment to human rights. And 4, the remuneration, allowances, benefits, and other terms of conditions of service of the Executive Director must be determined by the Minister with the concurrence of the Minister responsible for finance. And then in terms of 5, when the Executive Director is unable to perform the functions of office or when the executive director's position is vacant, the minister may, with the concurrence of the relevant parliamentary committee, designate another person to act as executive director until the executive director returns to perform the functions of office or until the vacant post is filled. And two, in the event of the executive director's position being vacant, the position must be filled within 6 months from the date of such vacancy, in accordance with the process contemplated in subsections 1 to 4. Then C, if a position is not filled within 6 months, the minister must request the relevant parliamentary committee and the Minister for Public Service and Administration for an extension of a period which must not exceed a further 6 months and provide reasons for the delay.
Thanks very much.
Clause 4.
Thank you. Go back again to the beginning of clause 4. There is clause 4, honorable members. Let's interact with the clause. Honorable Whitfield.
Thank you very much, Chairperson, and I'd like to commend you for the manner in which this meeting is being conducted. Chair, I did circulate, as you're aware, and the Civilian Secretariat has commented on the draft private members bill, which I had worked on some years ago. And I've taken note of the Civilian Secretariat's views. However, I maintain the position, Chair, and having recently read the McBride judgment, perhaps you will agree that by reinstating the existing section of the Act back into this bill, once it was taken out and sent to Parliament in the most unconstitutional manner, we are effectively doing the very bare minimum. And I want to thank the Civilian Secretariat for including section C, which deals at the end of this clause with the extension period. I think that is a very solid input from the committee, which closes the loop on the delay that we saw in the appointment of the current executive director, where the minister missed the deadline, was in breach of the Act, but the Act made no provision to close that feedback loop. And I argue that we are doing the very bare minimum because the intention and the sentiment of the judgment expresses the importance of securing the independence of IPID. I believe that Parliament does have a role to play, and I don't believe there's any legislative impediment for Parliament to play a greater role in this appointment process. Now, Chairperson, I took note of a very important statement you made at the opening of the meeting, which was, let us try to find a middle ground. And so I'm happy to concede that my private members bill, the draft private members bill, is perhaps an overcorrection, which some members may see as an overcorrection, and perhaps there is a compromise position in this clause. And that I would like to propose two ideas or two proposals for the committee's consideration. As you can see on the screen, it says the minister must appoint a panel to assist the minister, and then it says in accordance with a procedure to be determined by the minister. I believe that either the minister must appoint a panel in accordance with a procedure determined by Parliament, by this committee, or Parliament must appoint a panel to assist the minister to identify suitably qualified candidates. The other option, which is a third option, really, is to say that the Act or the amendment bill should propose categories of individuals who should serve on this panel. And either those nominees for that panel, who can be nominated by the minister, come to Parliament for its approval, or the deliberations of that panel serve before the committee while considering the nominee. But to exclude Parliament at this stage, for me, is problematic. And I think that there are a number of compromise positions that we can find here, where we can hopefully find one another. But I want to just remind the committee that the previous panel, which was appointed by the minister, had 3 members or two members of cabinet. I think it was Minister Stella Ndebeni Abrahams, Deputy Minister Kasamatale, and the Minister Ronald Lamola, and then only one civilian. And I believe that that does not sufficiently insulate the appointment process and protect the independence of that process. So I would request, Chair, that we consider a deliberation or a debate around how we find this middle ground around the appointment of the panel or the procedure to be determined, or how that panel is composed or constituted with academics, members of civil society, a judge, etc. Thank you, Chair.
Thank you, Honorable Whitfield. Honorable Peacock.
Thank you, Chairperson. Let me take this opportunity to welcome the presentation, acknowledge the Minister as well as the DM, and acknowledge the National Commissioner as well as the team from SAPS. Chairperson, from my side, we've heard what the latter speaker have already said, which is Honorable Whitfield. My issue towards my submission with regard to the clause 4, Chairperson, I'm not going to be long, as I believe that the work that was done in order for us to be given a clarification with regard to the appointment, I therefore propose that we accept the recommendation given here, as it has its own clarity on it, that the minister appoint the executive director, and the minister, as agreed here or as stated here, that the minister will be able to appoint the panel, not excluding the portfolio committee, but also showing that the portfolio committee will play its overall oversight role in order to foresee or to oversee that the processes is well followed. To me, Chairperson, is that I believe that the reason we've got a minister, we've given the minister the powers that he has, and as per stated, with particular laws that justify why the minister should be a minister, it obviously will also state his responsibilities. And I believe that because we've entrusted the minister on the position, we are also entrusting him of taking such decision of appointing the panel, as well as dealing with his work, of which when we say that we should be involved on that, how are we going to be involved on that? Because according to my understanding, that also needs that the person appointed need to be evaluated, need to be assessed. There's evaluations that have to make, performance management that has to be looked at, and that is not the role of the committee to do. So as I'm sitting here, Chairperson, I'm agreeing to what is being presented with what I've just stated now. Thank you so much, Chairperson.
Thank you, Honorable Peacock. Honorable Golding.
Thank you, Chairperson. Having listened to what has been presented and also the feedback from Honorable Whitfield, I do agree that while the Public Service Act does seem to indicate that this is within the purview of the minister, I do think it would be prudent for us to at least put out a template for the composition or the further composition of the panel. It appears we're looking to add delegates from civil society or independent organs versus just having that closed grouping as mentioned. So that's the first point I'd like to touch on. Please indulge me, I've gone back to my notes because we've been going through quite a bit. And it speaks to the appointment and very specifically the time frame. I'm trying to find the specific clause, but my understanding is that the ED is appointed for a non-renewable period of 7 years. I do believe in in one of the previous sessions, Honorable Whitfield asked why it was 7 years and not just 5. 7 years appears to be, and again, we've been called out on not treating IPID like a Chapter 9 institution, which it isn't. The 7 years appears to be coming out of the Chapter 9 institution. Because if I look at the SAPS Act, well, the commissioner is appointed for a renewable period of 5 years. And I'm wondering if that shouldn't also hold true for the ED of IPID, because if after 5 years the person's doing an excellent job, should we not be able to extend their service? Because in the service case, we're treating IPID like a Chapter 9, but in the rest, we're not. So possibly just a comment from Advocate Bell on that one. Thank you, Chair.
Thank you, Honorable Golden. Honorable Kharike.
Yeah, thank you, Chairperson. Chair, first and foremost, the EFF would not have a problem with a term of 7 years. So that can stand in terms of our understanding. That's the first point. The second point is we've already said in last week's deliberations, and the committee has accepted there was no counter proposal to that. And therefore, I cannot understand that we ponder on this again. That we have said, I have submitted that we cannot abdicate the authority of the minister. And I've explained that at length as to why and who the minister represents and so on. This committee represents Parliament. It's an extension of Parliament. So even this committee, when this committee decides on this policy, this committee must make sure that it succeeds constitutional muster or stands constitutional muster, and therefore the debate. So the minister must have the authority, because the minister will inevitably have to work with that individual in order to create a better SAPS, better conditions, and so on and so on. So let that be the prerogative of the minister to appoint also a, what is this here, to appoint a suitably qualified candidate and appoint to assist the minister, the panel. Let the minister appoint the panel, but on that one, can we ask, respectfully so, that most probably either we define panel and how many people should be in that panel. If that will give us some clarity in terms of the way forward, that is fine. Let us just understand who will then be part of that panel, because I submit that as much as we'd like to have our colleagues on board to come and assist in that panel, it will be misconstrued one way or the other as to say this was political interference. This we don't want. We don't want political interference. The minister is a political head of this organization, that is fine, and therefore we must trust his bona fides and give him the authority to move on. But we must understand who is this panel, who will consist of, we don't need to have names, but what does this panel look like? Is it a broader spectrum of civil society, or is it a handpicked by the minister? Or, you know, we must understand this in the legislation and then work in a clause in this section so that we understand, yes, minister, here is the clause, you can go out, you can do accordingly. And we have assisted you as a committee not to fall in any trap, so to speak. So whenever there's a backlash or there's some other views, that the committee, the entire committee must then defend the minister and defend the position of the bill. That's the submission of the EFF chair, and I would love to hear the legal opinion on my submission. Thank you so much.
Thank you, Honorable Kharike. Honorable Malekwa.
Thank you very much, Chairperson. Let me also appreciate the presentation on Section 6, subsection 1 on the appointment of the panel by the minister. Chairperson, I think I want to agree with Honorable Peacock proposal that we must accept the proposal as it is, because I think what the members proposing, I think this is going to prolong the process. And then, as we know that we have there are processes that should be followed, and there are time frame that the executive director must be appointed. So if we follow this prolonged processes, it's going to take time. I don't think that the time frame will be reached as been proposed. And I think, Chairperson, obviously, the portfolio committee will be able to receive the report on the appointment of the panel so that the PC can be able to interact with the report. So I think what Honorable Peacock is saying, that we must accept the proposal, it makes sense, and I think I want to agree with Honorable Peacock. Thank you very much, Chairperson.
Thank you, Honorable Moleko. Honorable Marekwa.
Thank you, Chairperson. Good morning to yourself, the Minister, Deputy Minister, and all participants on the platform. Chairperson, I think I want to start on the point of what we see there on the screen. It says the Minister must. It's not saying maybe or shall, it's just saying the Minister must. And I want to agree with that and saying that it doesn't give the Minister an option to either or. If Minister has got the responsibility and must ensure that that panel is appointed, in making sure that the appointment of the ED goes on and smoothly without any hindrances. So I think there's no question about it. One would like to support that, to say that there will be responsibility, as much as we know also that the portfolio committee has also a role of conducting its oversight. It will from time to time be able to check on these issues. But also, Chairperson, I would like to clarify that the appointment of the ED, Executive Director, is different from those of Chapter 9 institutions. You have your CGEs and others that where the committee, a committee of portfolio committee from Parliament will be directly involved. But this is a different case in that the ED falls within the Public Service Act. So it gives the minister that a responsibility or that right to ensure the appointment of the ED and so on. But we should not forget the role of Parliament through its portfolio committee, which is this committee of police, in ensuring that there will be oversight in processes conducted and making sure that things are going according to book or according to the law or according to the act. So there is no question the minister will must appoint the committee. So I would like to support the submission there, Chairperson. Thank you so much.
Thank you. Honorable Golding, is that a leader's hand or a new one?
It's the fresh hand, Chair. Just following up from the last commentary. The submission made or as adjusted by myself and on Whitfield was that we understand and recognize that in terms of the Public Service Act, it is the responsibility of the minister to appoint, as stated on the current screen. What we are requesting, though, is that we do put forward a template for the panel for the minister to then use. Those members would be appointed by the minister, but what we're trying to avoid is to ensure that the panel, as indicated last time, was loaded with 4 ministers and 1 independent. So prudence says just appoint extra members from the broader civil societal base. It's really just a template which the minister will then use, which gives us, well, I won't say better oversight, but more confidence that there's less interference. So it seems to be growing that panel size. I don't think it comes at a time cost. But the problem is it will come at a time cost if the recommended candidate, as recommended by the small panel, is rejected by the committee. So I think it is prudent to look at the recommendation, which is put forward by the Honourable Whitfield, look at how we can meld that into this process by putting forward a template for the composition of the panel, not in breach of the framework or the Public Service Act. I think that is the compromise which you mentioned early on. Thank you, Chair.
Thanks very much. At least I can see that we are now narrowing the gap. If you have spoken, please lower your hand so that I don't get confused. Honorable Peacock, is it a legacy hand?
Yes, Chair. I'll lower it now.
Okay. Honorable Terplanch.
Chairperson, thank you. Chairperson, I think what is important is that we must determine whatever we're going to do in terms of this, section. We need to ask ourselves the question, are we going to go far enough, broad enough to comply with the wishes or the ruling, spelled out by the court? And that is something that, I am not totally convinced of at the moment, and maybe Advocate Bell can just, add something, because there is the problem maybe that we are not going far enough, and otherwise I'm agreeing, with the direction that is taken, but I have this question.
Thank you very much. Honorable Gerike.
Yeah, Chair, apology, I did not appreciate the presence of the Minister and the Deputy Minister because I came late into the meeting. Apology. But let us assist the committee by saying there is no objection to the formulation of this bill as it stands. No objection whatsoever. It's just a question of, I think, semantics. And therefore, we're asking clarity in certain things. We don't ask for any compromise because the committee has moved already on many of these issues. But I think we must understand when we're talking about the panel, even if we put in brackets or whatever, or an A or a B or a C in terms of who this panel will be, but you cannot, we are not in favor of frustrating the minister or, taking away the power of the minister. This is not what we say. We are in a constitutional democracy. There's a delegation of powers, and the minister must do that according to that delegation. But we must understand the panel. We must say the panel will consist of civil society organizations or from government or whatever the case may be. That is to narrow the gap, that there is no misunderstanding of who, or there shouldn't be a gray area of who should be part of the panel or not. I am not going to be prescriptive to say it must be a professor from university or a judge or so. This is not what we say. We just want some kind of description. If it's not possible, that is also fine, but it's just to give fairness to the entire process. But the minister, it's not in dispute that the minister must appoint. That is not in dispute. I don't want us to waste time of that. It's the power and the authority of the minister. But the process must be fair and just. That's it. Thank you very much indeed.
Thank you. You can lower your hand so that I don't get confused. I'm going to recognize Honorable Whitfield, but I want the Secretary with the Advocate Bell, because we're almost agreeing. The remaining part is this definition of the panel. Honorable Whitfield.
Yeah, Chair, I just want to clarify that we haven't come to the phase of the meeting where we object or accept. So members shouldn't prescribe whether this is about semantics. We're amending legislation, and we have every right to be prescriptive. And I think that we are trying to find consensus, which appears to be happening among some members, that the panel should be defined and that there should be a role for Parliament. I have a fundamental problem with the minister having unilateral powers to appoint and to determine procedure. That is exactly why we're having this discussion. And the discussion hopefully will land on consensus. And I've made clear proposals, and I believe we should prescribe how the panel should be constituted so that the minister's powers, while he maintains the right to appoint, are curtailed by the legislation which insulates IPID's independence. Thank you.
Thanks very much. I think we are going somewhere. Secretary and Acting Secretary and Advocate Bell. I think Mr. Simani can also come in. I think we agree. At least there's an agreement that the minister must appoint the panel. Can you respond to this prescription of the panel? In the panel, it must be representative of what, or one word that say the panel must be representative of what, legally. Because Honorable Kherike said he would want a legal opinion on this one. Is it difficult? If it's difficult, it's fine. Acting Secretary?
Thanks, Chairperson. When we started in a previous, rather in our presentation, I think it's slide number 3, we had presented the protocol that is used in public service, where we indicated that in terms of the public service regulations of 2016, which is in line with chapter 4, part 4, rather, which is part 4, rather 67 subsection 2A, it prescribes how the panel should be constituted for the national heads of departments or of government entities. In this case, we are talking about the executive director, who is supposed, or who is the head of a national entity or government institution. So according to that, if you look at, I think it's slide number, rather bullet point number 1, the composition of the selection committee for the appointment of national department shall be chaired by the executive authority responsible for the portfolio. And then it goes on to say it must also include 2 other executive authorities. And it also makes provision for the head of a department, of a national department, to be also included. So this is how all heads of national departments are rather the panels for the appointment of all heads of national departments are constituted. Then what is different is that apart from this process, in the case of the executive director, there is always
You're breaking, we can't hear you.
No, I think it's you, Chair.
Sorry,
I can hear clearly.
Sorry, Chairperson.
Or maybe
so
it's on my
I was
side.
explaining the first sub-bullet point. I will request Advocate Bell while I try to log out and log in back.
Chair, we
can hear Secretary.
Hear him very well. I think the problem is with the chair.
Yes.
Okay, so in that case, I was explaining that what we have brought in the bill is in line with how other or all other government heads of departments are appointed. But in addition to that, we have put clauses that ensures that the role of Parliament is not diminished. Maybe it is a question of how far we can go. So our submission to the committee is there has to be that overall, rather oversight role that the Parliament is playing, but while at the same time not deviating away from the public service regulations, as these are the regulations that governs all the appointments of heads of departments in the public service. So that's our submission, Honorable Chairperson.
Chair, if I may, there was a question
Am I
by
audible, honorable members? I don't know whether the problem is with me.
You're audible, Chair.
Audible.
Am I audible?
May I continue?
Yes.
Yes, you are audible, Chair.
Yes, continue, advocate.
Thank you, Chair. Chair, in addition as well, Honorable Golding also spoke about the non-renewal period. This was also as a proposal that came from the public as well as from the members in the portfolio committee, and we want to say that it is also it's not only in line with the Chapter 9, as Chapter 9 people are appointed in terms of non-renewable 7 years, but it was also initially in line with the DPCI head. As the Constitutional Court had ruled on, and we were asked not to have less than 7 years and not more than 10 years. So the compromise that was made was for a non-renewable period of 7 years. So that's where that fixed period comes from, Chair. Yeah, and just to add to what the Secretary was saying is that we have stated that there are checks and balances that can be deemed as being sufficiently insulating the ED from political interference, because it's not only the portfolio committee who actually agrees or does not agree on the appointment, but there's also the minister from the of public service administration who will further get the appointment from cabinet as well, whether or not the person appointed is suitable. Thank you, Chair.
Thank you. I think I was having a problem with connection. I didn't hear a lot, but thanks very much for the responses. Mr. Simani, do you want to say something?
Good morning, Mr. Chair. Yes, my colleague, Mr. Njigela, will be making some input. Mr. Sivuwe Njigela.
Okay. Continue, Mr. Njigela. Mr. Njigela?
Recording in progress.
Mr. Njigela?
Sorry, Chair. I was trying to get hold of him. It looks like there's some connection issues there. But if I may chip in, Mr. Chair, we have noted the submissions that were made in regard to the composition, or rather the appointment of the panel by the minister. Just to recap, Chair, on the issue of the McBride judgment, just to put the issue that were dealt with into this context, that the McBride matter, it is an application to the High Court which related to the review and setting aside of a decision by the Minister of Police to suspend the Executive Director of IPID. which the court found that to be inconsistent with the constitution or the independence of the IPID as protected by Section 206(6) of the Constitution. The court held that this Section 3A and Section 6(6) of the IPID Act were inconsistent with the Constitution. This was, of course, based on the fact that this provision did not provide for a parliamentary oversight in relation to the suspension, discipline, or removal of the executive director, as they afforded the minister unilateral powers and sole discretion to terminate the executive director's tenure in the office. Now, why I'm bringing this, Chair, is that although the McBride judgment didn't deal with the appointment of the executive director, because as it was then, the Principal Act made a provision for a parliamentary oversight in the appointment of the executive director. Hence, the subject matter of the application was, in fact, the removal of the executive director. But one of the things that actually cut across in relation to both instances, that is the appointment and the removal, is that the court look at the lack of parliamentary oversight in the removal. So by extension, in this instance, even in the appointment of the executive director, that is, it actually threatens the structural and operational independence of the IPID. Now, coming to the question that is before the committee, whether it will be suitable for the committee to prescribe how the panel should be constituted. Well, our view is that there is nothing against the law in having the minister to appoint. He has the powers to appoint the panel. However, having said that, even the committee may sort of lay out sort of the criteria of, or rather the composition, how the panel should be constituted in an endeavor to ensure that this appointment of the panel is not necessarily an exclusive purvey of the minister, in line with the issues that were discussed in the McBride judgment, to ensure that there is an oversight. I believe Section 6.2 of the amendment bill makes that provision, in that now there is a parliamentary oversight rule in terms of the parliamentary committee that has the discretion to approve or reject such nomination. But in relation to the panel, well, our view is that there is nothing sinister if the committee were to decide on a sort of criteria that will sort of form part of the panel, which will ensure that the independence, that is the operational and structural independence of IPID, is guaranteed, and that the appointment process also sort of guarantees that perception even in the public, that in fact the process of appointment guarantees the operational and structural independence of the IPID as guaranteed in Section 206(c) of the Constitution. Thank you, Mr. Chair.
Thank you very much. Thank you very much. I want us to move on. I wanted to give a way forward, but I see Honorable Brandon and Honorable Gerike.
Can I go?
Honorable Brandon Golding.
Thank you, Chair. Just based on the last speaker, I think what we're looking at, and the executive protocol seems to indicate minimum standards. It uses the words at least. It doesn't prescribe the actual composition What we can do, though, is lay out criteria further to that, as indicated. It appears to be our purview to prescribe or specify a template which exceeds that minimum standard. Please note that the people filling those slots are still selected by the minister. It just makes it broader. So technically, he's protected more by this. And in terms of the McBride and the Minister judgment, it seeks to guarantee the independence of IPID. The judgment was looking at the removal, but as indicated by extension, the appointment too. So I think laying down further information as to what that composition should look like, noting that the people filling those slots would be nominated by the minister, protects everybody. And I think in terms of transparency and fairness and independent, it is prudent for us to then do. So I would recommend that we look further at the extended composition as indicated in the proposal or the members' bill, the private members' bill as laid down by Honourable Whitfield, and see what that compromise is, not mitigating that which was laid out by the protocol indicating the ministerial level appointment, but rather just adding to that base. Thank you, Chair.
Honourable Gerike.
Sorry, Chairperson, I think we're running in circles now. Because I think we're contradicting here what a previous speaker has quoted out of the Public Service Act, in terms of how it's spelled out, the involvement of the minister and the appointment. I think we must draw attention to that clause, because he read distinctively what the Act says, who should and who should not be involved. Now, we can argue here and we can say we may add to the committee, to the panel, and we may not add, and so on. It's all contradictions in terms of the current Act. The question then should be, in order for us not to delay to delay the process or postpone the process, should we accept the criteria or the legislation as stated in the Public Service Act as it stands, as has been read by somebody previously? Because we cannot argue past it. We cannot ignore it. It's an act, it stands, it has been accepted. And then if we abide or decide to include, or yes, oblige to that act, it stands then to be challenged by somebody if they want to challenge the composition of the committee or the panel. But then I think, because that act, the reading of that act gives me some other insight here. If we act stands, it simply means that there is a criteria in terms of the appointment of the panel. It means that we may not interfere then there. If we want to interfere, it will require another process, if I am correct in my layman's interpretation of the law. So it defeats the argument to say, how do we describe then the panel? Do we give a definition to the panel, or do we not give a definition to the panel? If we give a definition to the panel, it may be in contradiction with the current legislation as it stands. That's the point. So if the legal department can give us clear-cut guidance in this, must we say, then after we say the minister must appoint panel, do we say a comma, in accordance with section so-and-so of the Public Service Act, or what do we say? Do we say in accordance with what the committee has decided, i.e., people with extensive knowledge of human resource or legal background or whatever? How do we do this? The legal department must give us direction here. Thank you, Chair.
Thank you, Honourable Gerike. I didn't want to resolve this matter through a vote, but and I wanted the minister and the deputy minister to say something. They are not prescribing to us, but just to say their view. But I see Honourable Whitfield's hand. Honourable Whitfield.
Very brief, Chair. I think it's important for the record just to point out that we are. It's very clear from the previous presenter, Bulelani Simani, that we absolutely have the power to prescribe the composition of the panel, that there is no legislative impediment, as I indicated previously, that it would not necessarily be in conflict with the Public Service Act for us to do so, and that we as Parliament are legislators, and that is our function. We are entitled to do so. The sentiment expressed by the Constitutional Court was to strengthen independence, right, around the removal and ergo the appointment process. I think it's important just to highlight that the Public Service Act has been utilized to justify the status quo, but I would argue that there is an inherent contradiction then, because Parliament has been given the right to refuse the minister's nominee, which effectively is powers to Parliament to deny the minister his powers granted in the Public Service Act. And so I'm very worried, Chair, that this committee is going to produce a piece of legislation, if we're not very cautious and very careful, that will be taken to court and will be challenged if we do not do enough. And I think that a number of members have bent over backwards to try and find a compromise. But I suspect that the executive has an interest here that is shaping the outcome. And that would be very unfortunate, because if this is to end up in the courts at the cost of the taxpayer, it would be a terrible indictment on this committee. And I think that there is a compromise and a low-hanging fruit right in front of us that we should not overlook before putting this to a vote. Thank you.
Okay. I would want the Minister and the Deputy Minister to comment. Minister, on this point.
It would be nice not to comment, but because you're putting us on the spot, that's fine. But Chair, I don't see much problem if there is that extension. What I would maybe not agree with is the prescription of who do you put in. But if it is extended beyond what the DPSA regulations SOC Act say, that you extend beyond that prescription, I don't see a problem. The only prescription is that you are putting a practicant or you're putting a judge or what. That's one. But also we do need explanation of why would this department go beyond the generic that is there by the DPSA? If the DPSA comes back and say, what do you think you are doing? Where do we go? For me, those will be two issues. We'll have to explain that DPSA, this is my purview. I prescribe on this one. But if they agree with the extension, it should be an extension that this panel must go beyond what is prescribed. And we end there. Thanks, Chair.
Thank you. DM, do you want to comment?
Yeah, no, I think the minister has commented, Chair. The concerns that members have really are being addressed, and I think it's Simani on the input. Well, he said this can be. There is nothing harm in this elaborating on this, and at the same time, there is nothing harm with just having a panel as proposed here. The independence of IPID, I think the amendment addresses that quite adequately. I don't see how, for instance, if you say a panel must be broader, how that differs with what is returning. is written here. I really, I think it's more semantics really. Beyond this, I think the amendment as is here, it addresses that, because it's no longer a panel that says there must be 2 ministers and a head of a department. I think it's a different panel altogether. And like the minister says, it will not cause any harm if you say the panel must be representative enough or something like that. You know, it's more, I think it's semantics. The committee is playing a critical role, because if we come and recommend somebody the committee doesn't want, the committee will simply say, no, not this one. Start the process afresh. So no appointment of an executive director will be done without the role of parliament and through the committee, obviously. So the mechanisms that are put in place here, they respond adequately and appropriately to the Constitutional Court judgment, and will have responded appropriately. You can't appoint without Parliament playing a role. You can't expel without Parliament playing a role. So the incumbent who is appointed can't just be told what to do and what not to do, knowing fully well that he or she has the backing of Parliament. Nobody can expel her. That is guarantee enough for the person who will be occupying the position. And I must also express my appreciation, Chair, for members of the committee for having driven this process up to here. And I think generally we are agreeing with the sentiments that were expressed. And like I said, I think some of the things members are just saying them, but the amendment that are here guarantees, unless if they say the executive director is not protected by the insertions that have been made both on the appointment and on the expulsion, because like the constitutional, when the matter went to court, it was around the authority that the minister had to appoint and expel, and these mechanisms that have been put here addresses that. And I think, maybe I should just stop there, Chair, appreciating your contribution and how you have been driving these deliberations. Thank you very much.
Thank you. Thank you very much, DM. I think as a committee, we're agreeing that the minister will appoint the panel. The only area where we don't agree is extending the panel is already prescribed as per the Public Service Act, and members wanted to extend it. And I'm saying I'm trying to resist to resolve this issue through a vote, but if I'm pushed to, I will do that. I want to suggest that we continue with other clauses. Advocate Bell, Acting Secretary, and the team here, Mr. Simani, look at that. And before we close the meeting, you are able to advise, and the committee will take a final decision. I'm trying to be as reasonable as possible. Can I do that? And we continue. Otherwise, I'm going to resolve it through a vote.
Yeah, that's fine. I support your proposal. It would be useful, as you say, to get some feedback on how we could adapt that section that we've spent a lot of time on. But just to say, the minister's question is valid insofar as what motivations would we make to go beyond the DPSA? And that would be the fact that IPID is specifically referenced in section 206.6 of the Constitution. I don't know how many government entities or departments are. And I'm happy to come back to this and make some concrete proposals and hopefully be guided by the Civilian Secretariat. Thank you for your indulgence.
Thanks very much. Secretary Advocate Bell, Mr. Simani, work on that. We're agreeing up to this far. The only thing is whether you extend what is prescribed in the Public Service Act, and how do you extend that, and how do you explain to the Minister of Public Service and Administration with that extension. Let's go to the next clause 5. Anything, members, on clause 5? Agreed. Next one. Clause 6. Anything on clause 6? Agreed. Next one. Clause 7. Anything? Agreed. Next. Clause 8.
Chair, just
Agreed.
a question.
Clause 9.
Chair, could I ask a question? Sorry, I'm trying to put my hand up.
Okay.
Sorry, Chair, I haven't had a chance to look at what was removed from the delegation there. If we could possibly just get an explanation of what was removed from the delegation. But, I'm trying not to hold the process up. I'm just trying to understand. If Advocate Bell could explain that, please, Chair.
Advocate Bell.
What is it?
Clause 9.
Yes, Chair. What is being deleted is a reference to Section 7(9) in the Principal Act. Because what that provision provides for is that the Executive Director may, upon receipt of a complaint, cause to investigate any offence allegedly committed by any member of SAPS or the MPS, and may, where appropriate, refer such investigation to the National or Provincial Commissioner concerned. So this particular clause is the issues that the ED may not delegate. So by deleting that sub 9, it means that therefore that the ED may delegate this section.
Oh,
this,
okay. Yeah.
Yes. Okay, fine. Okay, thank you. Clause 9. Agreed. Clause 10. Agreed. Clause 11. Agreed. Clause 12. Agreed. Clause 13. Agreed. Clause 14. Agreed. Clause 15. Agreed. Clause 16. Oh, Honorable Whitfield.
Chair, just on clause 16, Chairperson, there were a number of concerns raised around the types of matters to be investigated. And there were some concrete proposals that had been made insofar as the issue of common assault. And there was a concern that the limitation to only investigate cases of assault, GBH, would cause or has caused concern. And while SAPS has the right to use reasonable force, I think to remove this, I think there should be a deliberation on this or an explanation as to what discretionary powers IPID may or may not have to either investigate or refer to SAPS's disciplinary process or defer. But I think for IPID not to investigate any matters of common assault or any complaints of common assault is problematic. And I would just like some sort of explanation from the Civilian Secretariat whether any consideration was given to give IPID discretion to investigate those cases.
Acting Secretary or Advocate Bell or Milton.
Thanks, Chairperson. Yes, we have considered this, and maybe just to remind the committee that the Deputy Minister had repeatedly indicated that we work as a team together with the IPID. So we have discussed this. But apart from what we have here, the Principal Act already gives IPID the discretion, I think it's in terms of Section 9, subsection 9, where they can investigate any other matter. So it means even in a case of a common assault, if someone brings a complaint to IPID on a common assault, it will definitely be investigated. So what we have avoided here is to have it as it was, which, as we have indicated, led to a situation where all manners of cases were brought to IPID, which most of the time were not necessary. Thanks, but I will allow the legal people maybe to even give a more technical response, and I mean a response looking at the technical issues here. Thanks.
Advocate Bell.
Honorable Chairperson, Minister and Deputy Minister, honorable members of the committee, colleagues, we just want to emphasize the fact that this provision amendment was actually necessitated by our statistics and our practice in terms of how we deal with the investigation. Although I don't have raw data at the moment, numbers dictate that a lot of our matters are generally common assaults, which never end in court, and in some instances where after investing a lot of resources trying to investigate, we find that the complainants are no longer interested in the matters. So we invest a lot of resources and time, but we don't achieve anything out of them. Some are rejected by the prosecution authority. Some the complainant abandon, they don't have interest. But more particularly, Chairperson, the fact that a lot of them occur in the course and scope of police executing their duties, for example, effecting arrest. We know, we live in South Africa, we know the attitude of the South African citizens. We know how they behave towards the police. A simple command that get into the van always leads to other things. And we find the police being stripped of the authority to use minimum force to arrest. Some of the complaints that we received as IPID related to handcuffs, people saying the handcuffs or the strips used to secure the suspect were too tight, and later on the case is abandoned. So having looked at all this statistical information, we came to a conclusion that this is not productive. We have to deal with it in this particular way. But as a safeguard, and as Mr. Ramaro indicated, the executive director still has the authority to instruct investigation when complaints of this nature are received. Furthermore, basic screening will be done to determine the extent of the assault for it to be pursued or to be classified as common assault. It's not like all is lost. There will be safeguards to ensure that our citizens, law-abiding citizens, are still protected. Thank you.
Thank you. Honorable Whitfield.
Thanks, Chair. I just, in response, and I see there are other hands, so I will be brief. That doesn't entirely satisfy the concern. I mean, the question really is whether IPID should be given discretion to elect to investigate common assault or to be able to refer those for police investigation, thereby, and I'm very compassionate to the caseload issue. We know it's a problem. We know that IPID is under-resourced and overloaded. And so I think by giving IPID discretionary powers where we say may investigate common assault or alternatively refer it for police investigation, it gives them the powers to define which cases of common assault are more serious than others. And it is not the case that the Principal Act resolves this dilemma. The Principal Act in Section 9, which was referred to earlier, it says that, let me just quote it, the Principal Act, functions of National Office, the functions of the National Office to, and then it lists a whole series of functions and says, deal with any other matter referred to it by the Minister. That is not sufficient. That is just not sufficient. It is not adequate. If a member of the public suffers common assault at the hands of a police officer, they should be able to either have that dealt with by SAPS as disciplinary procedures or by an independent police watchdog, which is expressly empowered to investigate such matters by the Constitution. So I think that while I'm compassionate to the workload, Chair, that this is a very serious omission in the Act or in the amendment bill, and the Principal Act does not satisfy my concerns in this regard. Thank you.
Thank you, Honorable Golding.
Thank you, Chairperson. Just looking at this, I know that this was a substantive portion of the feedback from both Mr. David Bruce and I think Mr. Daniel Kotze with regards to the workload. I was in support of being able to separate the two, where GBH would trigger a full investigation and common assault maybe not. But I think in the maybe not is and possibly that this touches on what Honorable Whitfield is saying. How is that dealt with? Is there a finding? Is there a contacting of the complainant to ensure that they want to prosecute this or follow up on it? I'm just looking for guidance while understanding that we want to reduce the fact that it may trigger a full an investigation, maybe not must. Is there common ground with dealing this? I would take guidance from parties here present. And then the last one, Chair, just on Section B here, it speaks to municipal police service committed together with any law enforcement agency or civilian. I'd like to unpack that, because when we tried to deal with other law enforcement agencies previously with regards to full IPID oversight, it was indicated that it was not constitutional. So I'm not sure what this means. If we can just get clarity on that, please. Thank you.
Thank you, Honorable Gerige.
Yeah, Chairperson, the committee or members of the committee are representatives of the public, and we must not lose sight that we must protect the interest of South African citizens. We are not in the structures of the police force. We are not generals. We are not commanding officers. We are public office bearers. Having said this, we must take into consideration the need for legislation to protect the citizens of our country. That's the bottom line here. So we have made a strong point in the last meeting about the definition of common assault and when not to investigate or to intervene. And there was the understanding that the workload is heavy. Yes, we've agreed with that. And there were statistics given. But there was also an understanding that discretion may be used. All depends on the statement submitted or the interview. And I think we must leave that open for a discretion to decide, because members of the public are running left, right, and center, back and forth to the police, laying charges, getting at the NPA. They refuse to decline to prosecute, and people are not getting anywhere. And having said this, and I know that you're going to tell me this is not for the committee to know, but then again, all those things that happen on the ground have got political implications for every party represented in the parliament. So that's the first point. The second point is we cannot leave open or a blank check written into legislation, even though it's unspoken, that we say, oh, no, we will not act against a common assault, or we cannot investigate common assault. It's a blank check given to the police to do whatever they want to do with the public. When they want to smack somebody or whatever, they can do it, because there will not be complications or implications for them afterwards. We must put into place measures to combat these type of actions from the police side also. We understand that the public gets provoked. We understand that the public is provoking the police, but we must protect police and we must protect the public. Therefore, I stand by my submission as in the last meeting that yes, the proposal will be that the IPID must use their discretion to ascertain whether there's merit in the case to investigate or not. In terms of common assault. Thank you, Chair.
Thank you, Honorable Gerike. Honorable Marekwa.
Thank you, Chairperson. Chair, looking at this clause 16, GA, where it talks to attempted murder in relation to a police or officer that discharges their firearm on duty. I think when we talk to release of firearm or using of their firearm as police officers, is part of their duty, Chairperson, where we know that the resources and the minimal resources that IPID has, and not wanting to have a backlog of cases. I think during the physical meeting that we had in Parliament with all members or all participants, we dealt with the issue of discretion in terms of which cases shall be referred back to the police and so on. So I think it's trying to assist IPID in making sure that they're able to deal with cases that come to their attention, and making sure that they investigate, but to avoid that there is a backlog. I want to support the submission, Chairperson, in that the attempted murder and also only cases of assault GBH, because if you have to report every case that is a police officer having used their firearm somewhere else and send it to IPID, where there's no injury, where there's no persons or maimed or so on, I think it will just create more problems for IPID, Chairperson. So I would like to support the amendment as presented here for us today, that let us stick to those for now, and that the issue of discretion, we have dealt with it. IPID or whoever responsible, the ED and let's say IPID, will definitely be able to see, but this is not for us to can deal with. We will refer somewhere else, but let us not overload them with too much cases that will from time to time come to them, because almost every week then there will be a case, or every day there will be a case of a police having used their firearm in public or where else. But also if the discretion talks to all, whether there are people injured or no people injured. So I think on that one, Chair, I support. Thank you.
Okay, thanks very much. Secretary, you want to respond? Or Advocate Bell?
Okay, thanks, Chairperson. Maybe the only issue that I wanted to raise is, I think it's Honorable Whitfield might have got me wrong in terms of the section. The section that I referred to is section 9, rather 7, subsection 7, which if I quickly read it, apologies, it reads 7.9. The executive director may, upon receipt of a complaint, cause to investigate any offense allegedly committed by any member of SAPS or municipal police service, and may, where appropriate, refer such investigation to the national or provincial commissioner concerned. So that is the section that we have considered, which covers it gives the ED the discretion to investigate whichever case that can be given to them. So that's the clarification that I thought I need to give a Chairperson.
Okay.
Thank you, Chair.
Thanks,
If I can just also come in here.
Yes.
There is an additional safeguard with that clause, Chair. If you look at clause 16(1)(h), that reads, any other matter referred to it as a result of a decision by the executive director or provincial head, or if so requested by the minister, an MEC, national commissioner, or appropriate provincial commissioner, national head, or appropriate provincial head of the Directorate for Priority Crime Investigation, executive head of the relevant municipal police service, municipal manager, or the secretary, as the case may be, in the prescribed manner. So cases of common assault can also be included in the referrals that are made to the people that I just read out. Thank you, Chair.
Thank you. Can we agree, Honorables, that as they've responded, it covers cases of common assault?
Chair, can I come in?
Yes, Honorable Gerike.
Chair, I don't want to waste time for the committee, but I think we must respect each other's views, and when we debate, we must debate frank and honest. We must respect the rights of people. South Africa is a constitutional democracy, championed by the ANC, by nobody else. So when there are issues where constitutional rights must be protected, we must be explicit in it. We've already said here, colleagues, with due respect, that and by the spirit of it, but not by the letter, by the spirit of it, we say, oh no, we will not take a lot of notice about common assault because the workload is heavy. That is the understanding here. That's the spirit. But if there is a matter where common assault affects an individual directly on the ground, for instance, a woman has been shunned around by a policeman when she has a baby on her arm and she falls on the ground. That's serious in the eyes of the public. And we cannot be reluctant not to address it, even though we don't describe it in the act as the woman that has fallen, but we must give explicit definition to common assault when it can be taken into consideration for investigation by ADPIT. Those are the matters that we're talking about. We're not talking about brushing just over stuff, Mr. Chairperson. It's about the constitutional rights, but it's also about the constitutional rights of the policeman that say he has got the right to use minimum force versus common assault of the general public. And I thought we're going to debate this instead of just rushing over this, debate it and say, okay, in mitigation, let us put in A, B, and C in order to protect the rights of the public. Those are the things that give justification. People will again I have faith in our system, Mr. Chairperson. This is what we are trying to do here because the courts have wrong. Thank you, sir.
Thank you. Honorable Golding.
Chairperson, just before we close this section, I did just seek clarity on section 16B with regards to law enforcement agency and civilian. Thank you, Chair.
Okay. Honorable Whitfield.
Yeah, Chairperson, thank you very much. I just want to say, Chair, that the explanation is satisfactory. I believe there's sufficient provision for any complaint to be lodged. I appreciate the explanation, and I will take this battle up with the Executive Director, because by removing common assault from this section, it's very easy to simply dismiss every case as not requiring investigation simply because it is common assault. I accept that there are other provisions that allow members of the public to lodge complaints, but there is a risk that they simply get dismissed because there's no specific reference. And that is something that this committee needs to consider, and we will have to look at very carefully going forward. Thank you, Chair.
Thank you, Honorable Whitfield. Can we respond? Honorable Gerike, do you want to come back?
No, sorry, sir. My hand, I will lower it.
All right. Can we clarify Honorable Golding's issue? Secretary Advocate Bell. Did you get it?
Advocate Bell, I think I missed it. Advocate Bell.
Advocate Bell.
Thank you, Chair. I also missed that. What exactly must we clarify, please?
The question was section 16B. It's together with any law enforcement agency or civilian. I'm not sure why that is specifically there. Thanks.
16B.
It's out of the investigations, Chair.
Yes.
Honorable Chairperson,
yes.
Ramafoko from IPIT once again. Let me just indicate that this insertion was actually necessitated by our observations in practice, where police, SAPS and MPS members act in cohort with civilians. When one conducts investigation, you'd be told, no, you cannot investigate me. That would be from the civilians. You can't investigate me. I fall outside your mandate. Whereas they are acting in concert with the members of the police. So there was a need to keep this problem, because we cannot have separated or split investigation where the same criminal offense is conducted by the police in cohort with the civilian. You investigate only the police and you refer the other part to the police to investigate the civilian. So as a result of this consideration, we thought it prudent that once you investigate the police and the civilians are involved in that offense, that must be extended to them as well, because we are using state resources, whether we are IPIT or SAPS, in investigation of crime, and multiple approach to the same crime would bear undesirable consequences, where you have one investigator having completed investigation with respect to the police in the same criminal offense, and the other one conducted elsewhere are not completed at the same time, and the docket has to be submitted. There are different views and so on. So to keep this problem and to ensure that justice is seen to be done, there was a bit of extension in terms of police acting with civilians. Thank you.
Are you fine, Honorable Golding?
All good, thank you, Chair.
Thank you. Want to move on, Honorable Whitfield?
Yeah, I know, Chair. It's very important that we clarify the issue of, and I've accepted the argument, but not the section, but the argument that there's provision for members of the public to lodge any complaint with the Executive Director. But again, just to reiterate and to get clarity from the Civilian Secretariat, how do they envision that those complaints of common assault will be reported to IPID if not explicitly reflected in the section? What would be the reporting procedure to ensure that issues of common assault, cases of common assault, can follow the correct procedure and that they are treated like any other complaint according to the reporting protocols and procedures of IPID? Thank you.
Thank you. Honorable Gerike.
Chairperson, can I respectfully propose that we move on, that we do not try to play politics here on an item that's important? Let us just move on. You have many speakers have expressed the relevant provisions in the law. The latter speaker, Honorable Whitfield, has just previously said that he is agreeing now. He's fine with the explicit definitions in the law. Now he's coming back again, holding us up. The moment when I submit something, he tries to counter it. That's not the way to move. Let us move on. The provisions have been explicitly read by the relevant officials. And I think let's stick to that. If there's provision in the law for people to complain about common assault, let us accept that and let us move on. I propose so. Thank you very much.
Thank you, Honorable Gerike. Let the Secretariat answer the question, then we move on.
Chairperson, I want to have the details on how the reporting happens, but I believe there are regulations, IPID regulations, that stipulates how reporting of or complaints are brought to IPID. And whether it's common assault or any other complaint, the procedure has to be the same, and the assessment thereof by IPID should be the same. Thanks.
Okay. Thanks very much. I think we'll continue discussing. Let's move on to clause 17. Clause 17. Agreed. Clause 18. Agreed. Clause 19. Agreed. Clause 20. Agreed. Clause 21. Agreed. Clause 22. Agreed. Clause 23. Agreed. Clause 24. Agreed. Clause 25. Oh, that was the final clause. I think we have agreed on clause to clause, as it will be captured in our report. Before we close the meeting, we'll just get a feedback from the Secretariat. Honorable Whitfield.
Yeah, Chairperson, I just want to say that you've gone through sections, said we agree to following sections. I don't believe that that's the case. You must ask individual members if they agree. I don't think that we went back to clause 4, Section 6, you said we would go back and look at the composition of the panel. Nobody's playing politics here. We are legislating. We are drafting legislation that can strengthen the independence of IPID. I don't think we need to rush this process, but we certainly do not agree with everything that you've cited, and I think that we will have an opportunity to come back but at the moment we reserve our rights, and if we're not going to go back to Clause 4, Section 6, which we said we would, then we certainly have a big problem. But maybe that was an oversight. Thank you.
No, I understand, Honorable Whitfield. I said before the end of the meeting, we'll go back to Clause 4 and get a feedback. And then based on that feedback, members will decide whether we agree or not. But generally, we're still going to, you still reserve your right. We're still going to present this to National Assembly, and every political party will have its say on when we present the bill to the National Assembly. But we're, like I promised, we'll come back to Clause 4 before the end of the meeting. And then I'm just trying to give them time to look at it, because they were focusing on the clause by clause. Now, when we deal with SAPS, they can look at it, then come back to us, and we have our view on it. We agree to disagree or agree to agree. Thank you. Honorable members, Secretariat, and I'll call you before the end of the meeting to give us a feedback. But for now, let's go to the presentation by SAPS. Honorable Minister.
Good morning again, Chair, and the honorable members, DM, and the management, Secretariat. Chair was requested, especially towards the members, the structure. What do we do to take on board the question of our members, their well-being, their welfare, and and their growth within the organization, as we're trying to make this organization the organization of excellence, not the organization where we grow up people getting dumped in it. I remember when I was young and you could not go very well at school, you were told, you were asked why don't you join the police. That's not the organization we're working on now. We want the organization of excellence, and the organization that when people are here, they grow, the safety of the members of the organization, the well-being, but also the discipline and the full understanding what is their job. So from the side of the management and the ministry, things will have to be done to improve that kind of feeling that you are in the right organization. Therefore, Chair, I request that through you, we hand over to the National Commission of the South African Police Service to take us through to the presentation, and we'll all take it from there. Thanks, Chair.
Thank you very much, Minister. Yes, National Commissioner, we're in your hands.
Thanks very much, Honorable Chairperson and honorable members, Minister, DM, and colleagues. We are going to, Chairperson, give a brief presentation on the human resource-related matters. That will be the conditions of service in the SAPS, discipline management in the SAPS, matters of employee health and wellness, the policies regulating the members leaving the service, which is mostly your Police Act and the Public Service Act, and also what benefits are these members having in terms of housing-related matters. And we'll then also give progress on on the matters of the organizational structure as to how far we are, Honorable Chair. I am handing over to Major General Divet to take us through the presentation. Thank you, General Divet.
Good morning still, Honourable Chair, Honourable Members, Honourable Minister and Deputy Minister of Police, National Commissioner, thank you, as well as also representatives of SAPS. Yes, Chair.
Yes, I just want, sorry for that intervention. I saw you have 40 slides. If you can spend a minute or less on each slide so that members are able to engage with the report. Thank you.
We will do so. I will do so. Thank you, Chair. I think the reason why we have so many slides is because we were caught up in indicating sufficient information in order to allow people to have a good sense of what the benefits and so forth is about, but also not to spend too much energy in terms of communicating unuseful information. But the idea, as you correctly indicated, is for me to not spend a lot of time on each of these slides. So I think the National Commissioner has already given an introduction, so we don't have to spend time on slides 1, 2, and 3. So if we can move to the 4th slide, please. Slide number 4. I see the slideshow is a bit slow. It gives a background on conditions of service in the organisation, and as everybody is probably aware at this point in time, people that work within the SAPS are appointed in terms of 2 acts, which is basically your Public Service Act and your Police Act of 1995. The people's conditions of service that is appointed in terms of the Public Service Act is being determined by the Minister for Public Service and Administration, and we have spent some time earlier in our deliberations about the act that they are playing a very important role as far as the directives for HR is concerned within the public service. Then as far as people appointed in terms of the Police Act, our Minister basically determines that. But there is always a hybrid situation that is taking place within our space. We have transverse benefits and conditions of service which is applicable to the public service as a whole. And then we also have benefits that specifically deals with the police part of it. And typically, all those benefits originates from a decision-making process by the mandating committee, which consists of ministers that takes decision in terms of these type of things. As far as our conditions of service that specifically focus on the police ones, it is determined by our minister, and we also then negotiate these type of benefits at the police PC. If we can move, I hope the slideshow will move, because I don't see it moving. Because the next slide basically gives us a breakdown of those 2 sets of information, those things that are transversal of nature.
The slides are not moving at all.
Who's moving your slides, General Duet?
General Rabi, I think he's just trying to reflight it, General.
Chairperson.
So we're just trying to contact General Rabi to find out what the issue is with regard to the slides. If you can just give us a minute, please.
Chair, can I make a suggestion because we don't have much time? I think we do have hard copies. If we do, or most of the members do, okay, looks like we're coming up, Chair.
Okay, thank you. Thank you, Minister. Continue.
Thank you, Chair. Sorry for that hiccup. If we look, for instance, at the slide in front of us, the benefits on the left-hand side is those things that are generic within the public service, and that is things that everybody is aware of. The things on the right-hand side is those things that we give over and above to the people within our organization, and you will see that there's a list there, and we will discuss each one of them because it is over and above, and I think that's where the value add is what we are looking for in our organization, and typically, it also gives us a good base to be able to say what comes next. If we can move to the next slide here. The first issue that we are going to deal with is the notches and pay progression. Now, I think the reason why we flighted this is because we normally, with our social partners, within what is affordable within our organization, identify the entry notches of the relevant levels within our organization. And I think this is a very important slide because when we get to things later on, like for instance, grade progression, which allows people to progress as far as salary is concerned and levels, with staying in the same post, these type of figures are relevant. Typically, the entry notch you will find is at 216, and a person can remain within a specific post, and he can retire at Warrant Officer B2 at 489,297, which allows for a long salary progression path, provided the organization has got sufficient rules of progressing people and it remains affordable for the organization. But the idea we have flighted is to indicate that this is what we are compensating people that are doing our day-to-day responsibilities. This is the production core. This is the people that is doing the policing. And if you see the entry notch and the top notch, the movement between those notches is 1.5%. It doesn't mean that you first have to achieve 262 before you can go to 271. We will get to how people progress from constable to sergeant a little bit later, but it's just to give some background information as far as that is concerned. What is important is that you can only get by progression if you on an annual basis get satisfactory performance. You can go to the next slide, please. The next slide deals with the medical benefits and the medical aid. SAPS is one of those departments, or not one, it's the only department that has its own medical scheme, which is called POLMET. And just to indicate more or less what is being provided to our members, we have a brought a comparative analysis on GEMS. GEMS is basically the medical scheme where the rest of the public service is on. And then obviously our people, the people appointed in terms of the Police Act on the POLMET medical scheme. Now, the point right at the bottom, it says that POLMET provides superior benefits with for less money, or basically to the employee. And that's basically what we are trying to illustrate over here, is that our lowest plan, which is comparative or similar to the GEMS Beryl plan, we can see that our employee contribution starts at 106, whereas in GEMS it starts at 1,338. Our highest plan, which is also our second plan, which is also the top end plan on GEMS, and we can see that our employee contribution starts at 432 vis-a-vis 5,359. Now, typically, as we know, we have to pay net money for our benefits, we can already see that that is a substantial difference as far as the in-pocket position of our people as far as medical aid is concerned. Another thing that PORMED does well is that it looks at our situation, it looks at our health profile and where the needs are to provide support. We also have an EHW representative that is also on the PORMED board in order to make sure that those things that is necessary within the organization gets translated into decision making on the PORMED board. We can continue with the next slide, please. The next slide talks to pension benefits. And as we all know, all government employees are part of the Government Employees Pension Fund. I think what's important for us, as well as for other service departments, we have to retire at the age of 60. Whereas in the rest of the public service, people retire at 65 years. We both, us and the rest of the people in the public service, contributes at 7.5%, but you will see a difference in the employer contribution. And that difference in employer contribution is basically to make up for the 5 years that we will not serve within the police service. And typically, it also, if we look at the enhanced pension benefit, if we have a very long period of service, we get extra years of service, and that's basically, if we compare ourselves to a person that's in the public service and they get salary increases whilst we are on pension, it's basically to cover for that as well. So the bottom line is those two bullets right at the bottom is very important, and it also just indicates that we get the same, but ultimately at the end of the day, we go early on pension. If we go to the next slide, please, talks to injuries on duty. When we look at injuries on duty, typically when a person gets injured on duty, he basically has to go, or she has to go to a hospital to be able to get treatment. And typically, if the person doesn't have a medical aid, then there's a lot of forms that have to be completed in order to be able to recover the money from the compensation or from the compensation and for occupational injuries and diseases act in terms of that. But because police officers belong to PORMED, when they go to a medical facility or a hospital after they've been injured, they can immediately access the benefits and PORMED pays immediately. So we don't have a situation where there's unnecessary forms that delay situation and guarantees for payment and stuff that needs to be provided. Because our members are on PORMED, they can access treatment immediately. They then also have the facility to later on engage with SAPS as far as payment for those injuries are concerned. And as we've indicated, that PORMED pays, but SAPS also, as we've indicated, pays for all the costs. Also, when the member is recovering, we put them on special sick leave so as not to, further burden them with unnecessary, running out of normal sick leave processes, etc. And it also doesn't impact on their annual leave. What's important also is if a person is incapacitated and he remains incapacitated for the time that the person is recovering, we pay a home nursing fee for 5,460, and if the member retires and he remains incapacitated, that will go and will be paid to the individual and assist as far as his home nursing is concerned. So that is a lifelong one if needs be. Move to the next slide, please. The next one is if, unfortunately, our members die on duty, we have, on top of the pension benefits, there is a once-off amount that's being paid to our members. We see the payment structure over there. What is important and what is different from our department to another department is that we pay the tax on behalf of the individual. So that amount that you see is what will be paid over to the families. We can move to the next one, which is clothing credit. When a person joins our organization and is a fully fledged police officer, he's been kitted out with all the necessary materials and stuff like that. And then there's 1,600 per annum clothing credit, which allows a member to maintain the uniform. in the event that this person chose to be a different career path, like for instance a detective, or even if our member is a police officer and becomes disabled, that 1,600 still remains applicable, and the person can use that credit in order to purchase civilian clothing. Move to the next benefit, talks to allowances. There's two categories that we are going to touch on. The first one is the service allowance of 700 rand. So if you're appointed in terms of the Police Act, but you do an office job like I do, the service allowance is not applicable to you. You have to be able to actively perform operational duties to qualify for this. What's important also is to see that right at the bottom, what we try to do is to make our administration a lot easier, and that we don't have to on a monthly basis consolidate a lot of information as far as standby duties and so forth is concerned. We basically looked at what is the profile of a police officer, and then see what money is being spent on that specific official, and then we converted it into a service allowance, which you see in front of you. The service allowance was increased earlier in the financial year, but typically a lot more has to be done as far as this is concerned. Also, our service allowance is not inflation linked, so typically at the end of the day, we always have to look for money in order to look after our people. At some point in time, we need to normalize the situation, because in other government departments, you will find that these type of allowances are inflation based, and typically, it's part of the budgeting process and so forth. The next type of allowance, we can move to the next slide, deals with scarce skills allowance. Typically, we have identified those occupations that is scarce, as we can see that the allocation was done in 2006, and due to certain financial constraints, we haven't increased the categories or increased the money. But typically, it is becoming a bit tough for us to continue to hold on to people, because you will find that even though we have a broad banding system, even though we have the allowances, typically we'll find that people, other departments and typically other institutions are starting to poach our people. And the next slide, if we go to that, it's typically the categories that you will find that we are paying these allowances for. It varies between 400 Rand and 6,333, and those are the people that qualifies for that. At this point in time, around about 5,200 people in our organization qualifies for these type of allowances to at least the value of about 80 million Rand. We can move to the next slide as well. It touches on promotion and grade progression. When I started off and spoke about entry-level salaries, I indicated from a constable to a warrant officer B2 leg, and you will see that in that slide in front of you that we have agreed with organised labour that we will have this two-pronged approach, a grade progression approach and a promotion approach. And then as part of the grade progression approach, people can progress from constable to warrant officer B2, and that's the reason why I've highlighted the difference in salaries. What it also says is if you want to progress from one level to the next, let's say from constable to sergeant or sergeant to warrant officer, it's based on 7 years. And it went well for a while, but due to financial constraints and so forth, and budget cuts, etc., it necessitated us to sit with labour and try to increase the years to make it more affordable. And as we can see, that took place in 2018. But we know that in the last years or so, we have again been exposed to that type of cuts. And as we can see, we have a backlog of members, and if we don't receive additional funding, we might have to sit again with labour in order to see if we shouldn't increase the period. We move to the next slide. On this thing right at the top is the other area that I'm talking about. At captain and above, there is an appointment process where posts are advertised and filled via open competition. I think the next slide basically just gives a bit of background as to how effective we were in progressing our people appointed in terms of the Police Act. And the bullet right at the bottom indicates that we are currently in a process to see if there's not a better and more affordable way of doing things promoting and great progressing our people. And there is a benchmark study that is coming up that will take us to countries with comparable policing agencies, so that we know what is current and what is workable somewhere else in the rest of the country. Then, as far as the next slide is concerned, on conclusion of conditions of service, is that we are saying that we would like any initiative or any proposal as far as this is concerned, but normally what we've picked up with conditions of service, if the budget doesn't come with it, there's not a lot of room to maneuver. And yeah, I think basically I've touched on the areas that we believe that we need additional funding for, like for instance, the skill, the great progression, and typically something that the organisation is passionate about that we cannot initiate is the detective allowance, because we know we need to make sure that we up as far our performance as far as those things are concerned. If we move to the next slide, it touches on discipline management, and we know that this has been an area where certain concern has been raised, but we thought that it's important to give a bit of background as far as our disciplinary regulations or our disciplinary code is concerned, where it originates from, and to whom it is applicable. I think all that information is there. And typically what is very important is that the process must be procedurally fair, and that the person receives a fair trial at the end of the day. If we can go to the next slide, it basically also touches on some of the principles, which indicates that discipline is a corrective and not a punitive measure. And I think ultimately at the end of the day, we have to keep this in mind. Also, our disciplinary processes are informed by the IPID investigative process, and typically we have our obligations as far as this is concerned, and we taking it very seriously. We have good numbers as far as that is concerned as well. We are trying to make sure that we are capacitating line managers in order to apply our processes fairly, correctly, and ultimately at the end of the day try to be as consistent as we can in meeting out the decisions that needs to be taken. But ultimately at the end of the day, organised labour has indicated that they would like to have a review to look at how we implement our processes and maybe what improvements can be made to the system. And that's the purpose of the last bullet on that slide. There is a working group that has already been established that is looking at this, and hopefully that will yield results that will allow us to improve. If we go to the next slide, we have included some numbers there. What is important, and obviously we're not going to dwell into those numbers, but what we can say is that if we look at right at the top, you will see the number of cases versus the number of process or cases that was finalized. You will see that slowly but surely we are making progress as far as finalizing those numbers. At this point in time, we are close to 65%, and in 2021 we were at 55%. So we are slowly but surely improving. Also, what is important is that if we look at the numbers at the bottom, third column from the right says progressive. Basically, as we've indicated, the correction of behaviour is very important as far as this process is concerned, and a strong, more than 40% of the people are being exposed to progressive misconduct, making sure that we have the right people that remain in the organisation, but also ensure that we correct the behaviour that is necessary through a formal process. Formal process is always invoked when necessary, but sometimes there is an informal process that precedes a formal process where a person's behaviours try to be corrected, but ultimately it fails, and then obviously it goes to a more formal process. The progressive process is where there was disagreement in terms of how it needs to be dealt with, but ultimately at the end of the day, a decision is being taken to, again, warn a person, make sure it goes through a formal process of corrective action and so forth. If we move on to the next slide, it touches on employee and wellness. I think that was also one of the areas that was targeted for us to give a briefing on. Firstly, there is a DPSA EHW strategic framework for government, and what we have indicated is that we are in compliance with that. Obviously, we need then professionals that will enact that strategic framework and make sure that it's customized for our organization. Typically, we have specific support that we provide. We do debriefing to people, but we also offer proactive and reactive programs in order to make sure that we support morale in the organization. The last slide indicates what we have in the organization. If we can move on to the next slide. The next slide, according to my recollection, touches on the registration and making sure that the people stay current as far as new developments are concerned in their fields. If we move to the next slide, it indicates in terms of how we would like our services to be executed. You can move to the next slide, please. Next slide. I think we have a glitch again, but hopefully it will catch up with us. I think, that is the one. It obviously foremost, it talks to confidentiality and so forth, and also some of the other things that are very important. If we move to the next slide, we will find that there is specific ways that we are communicating and are spreading the message, the health and the awareness and message within the organization. And those are typically the things that we use, from raising awareness to offering one-on-one support, to organizing events, also in terms of team building sessions and so forth. So if we can move to the next slide. Basically, it gives an indication as to the proactive programs that there is in the organization. If we can go to the next slide. And you will find that it is categorized under psychological, social, spiritual, etc. It is not all, but it should give a good indication. Also, we provide reactive services, and you will see right at the top, formal trauma debriefing and trauma management is very high. And for that, we have a decentralized capacity, HW capacity, that is available to be able to do that. As soon as a person is exposed to that, a EHW practitioner is available in order to provide the briefing, and we will see what the numbers are hereafter as far as some of these things are concerned. Right, we can move to the next slide. The next slide provides some numbers in terms of awareness programs and information sessions, and on the right-hand side, you can see how many we have done already during the course of the year. If we move to the next slide, we'll find that it deals with those things support, where one-on-one support is being provided. You can see there on the right-hand side as well. Also, right at the bottom, you will see formal trauma debriefing, which has to be provided subsequent to a traumatic incident. And you can see that we have already dealt with 2,056 people. You can see members there on the right-hand side that have declined to do that. We cannot force a person to go through debriefing, but that's where PORMED comes in, because our benefits are structured in order to provide our members with the necessary support. They can access a professional through PORMED in order to help them with the debriefing, should they so wish. If we move to the next slide, it talks to the relevant legislation that is applicable to service terminations within our organization. It's the relevant acts, Police and Public Service Act. It talks to the employment regulations of SAPS, as well as the regulations in the public service, and then also our national instruction, and then obviously, because people qualify for pension, the pension fund rules as well. Then, as far as service terminations is concerned, we knew typically that we will probably be asked the question, how many people leave the organization, for what reasons, etc. We've provided the slide not to confuse people, but rather to give an indication as to what has happened. Typically, when COVID struck, for instance, you will find that the numbers for deceased people went up during 2021, 22, and then there is some other figures as well, because I think we wanted to see what the situation is like. We are moving to a normalized situation as far as 22, 23, and 23, 24 is concerned. But what is important for us to highlight is the note right at the bottom. You will see that our average attrition rate is 3.3%. You will find that if you go and do your research, anything up 7% and between 7 and 9% is regarded as acceptable. However, as you can see from our attrition rate, it's at 3.3%. Then if you look at, for instance, resignations per se, what is the percentage that they think the industry norm is? We found that it's 3% and our resignations is 1%. So it's well below the relevant rates as far as what the industry norms are concerned. We have obviously our HR committee meetings, which meets on a quarterly basis, where all these figures are presented, and where we have a bit more information about the type of occupations and the people that we leave in the organization, where, at which division and which province and so forth, in order to allow us to do our planning for next year as far as providing resources, but also to make sure that if there is emerging trends, that we're in a position to deal with those. One of the critical things that we do monitor as well is our scarce skills groups, what type of people are leaving from them and at what levels and so forth, so that we're ultimately in a position to do that. I know that the question is going to come on retirements, but what we have picked up that even though people are going on retirement, our group at 55 and older, which normally allows your retirement to take place, have increased over the years. So it means that people are still staying longer in the organization. However, some exercise their right to go and some have to leave the organization. I think that is the last slide as far as my presentation is concerned. Thank you, Chair. I do not know if, how you will take the matter forward. I submit. Thank you, Chair.
Good morning, Honourable Chair and Honourable members of the committee, the Honourable Minister and Deputy Minister and National Commissioner, General Rabing. I just want to give brief feedback to the committee on the progress that we have made with the review of the SAPS organisational structure. As you are aware, the National Commissioner initiated the review of the structure. We have reviewed it, concluded our internal consultation processes, although there are currently some of those individual exercises that we have to conclude. The task team has drafted a draft structure after we had the consultation, as I referred to, internally, and it's currently being consulted with the parties that we are required to consult. That includes organised labour. We had a meeting with SAPU last week. We met with POPCRU last night, and in terms of the engagements with the two unions, we are required to have follow-up sessions specifically on the proposals that were submitted. And we also have to consult with the ministry as soon as we are at the tail end of the exercise. And at this point in time, the draft structure that we have is subject to change following the consultation processes that we had with SAPU and POPCRU and other interested parties. And therefore, Honourable Chair, it will then be more appropriate for us to present the structures when we have finalized the total process and allowed all the required processes to conclude, and requesting that we will then be allowed an opportunity later to present those structures as soon as they've officially been signed off. Chair, thank you. That concludes the progress on the structures of the South African Police Service. Thank you.
Thanks, Honourable Chair. That marks the end of our presentation, General Ravi, if I'm correct. Thanks very much.
Thank you. Yes, Minister.
No, thanks, Chair. That's a presentation on the question of the staggering death grant, Chair. There is a new approach that we have just agreed upon. They might say they haven't known or seen that. That death grant has not moved up since 2010, 2011. So, but in the realization, Chair, more people that die, they die at the junior level, at the constable, sergeant, and warrant officers, because they are on the ground. and they have not accumulated much, any form of financial accumulation by then. So that's why it staggers that those that are a bit on the high level, they stay as they are. Then those that are immediately, they little bit up, those that are lower, as you have seen the figures. We are trying other matters to make their life better, as they shouldn't take long in the organization to be comfortable. That's that. The other one, Chair, is though the percentage, according to the presenter, of people leaving the organization is within, it does give some problem, especially on the experienced side. People like detectives, you don't grow them in universities, you grow them in the field. So it's important that we try to keep them much as longer. We were looking, but it's a very initial stage. We are looking that while 60% is mandatory, 60 years is mandatory age for the police to leave the organization. Can't we say that maybe detectives, we keep them longer, so that we enhance that capability within the police? That is, as we speak now, we're inviting them more to come back to the organization, because we have really weakened them. The question of keeping our hours within the organization is also one big, the retention strategy is one big focus. Chair, we produce best people in this organization, whether it's in laboratory, in sciences, and all that kind of stuff, but also on the special forces. We have been very worried of late that there are many organizations that are recruiting from us, especially those special forces. Chair, we're top in the world when it comes to your special task force and all that. So very, very difficult to train and keep them. So we're trying to keep them, as you saw those figures, which are not enough. Though the army is still doing better than us. We would have loved to work on it. The private sector on this one is really beating us, recruiting our special task force and IU guys and our cats and all that. So it's one thing that we are trying to work on it. So the welfare, the taking on board the families, the death rate is quite high, and it frustrates internally and externally the family members, and all that is one area where we are trying to enhance, Chair, so that we keep the well-being of our organization. But one thing that the National Commission and the management, they've done very well, is a deal that they've done with two giant fitness institutions, that is your Virgin Active and the fitness, I forget the first name, but the fitness, they have had a deal with our members to have some cut as they join there, which is part of the wellness to keep them fit and all that. We're very pleased. We're still doing further negotiations on those matters to push it even further down, but also trying to create those facilities on the rural areas so that our members, they are kept fit, and which is part of the well-being and welfare, and better health and better response and better agility as they do their work. So those are the things that you are trying to work on this organization. Thanks very much, Chair. That is just icing on what has been placed by the presenter. Thanks.
Thanks very much, Minister, National Commissioner, and your team for a comprehensive presentation. I think it responded very well to the request by members of the committee to get a briefing on a number of issues. Of course, like you say, you are still consulting on the structure. I'm very much interested in that structure. I hope you'll come back after consultation. Can I get members, if you want to interact with the report? Honorable Golding.
Thank you, Chairperson. Just a few quick questions. The Minister touched on the 60 versus 65. Obviously, in the rest of public services, it appears to be 65. Is there reasoning why we're not doing people till 65? There may be some underlying legislation, but it seems to be quite a waste. I'm assuming we don't have many 60-year constables, so we're obviously losing experience, which is a problem. So that's the first question. The second one is maybe just for opinion. It has to do with counseling and then obviously mental health. I'm very concerned about mental health and trauma counseling. Our members do work in a very high stress and often violent space. So we'll be talking over an annual period of incidents where members were debriefed through trauma counseling. 2,000 represents about 1% of the force, which doesn't seem very high. Should that not be a focus? They do work in a very high stress space. Should we not look at mandatory counseling and prospectively regular group counseling? And then just the third one, it had to do with the attrition. Let me just get to the slide. Obviously, we're seeing here that our attrition rate versus our intake has slipped. I see there was a 12,000 gain in the past year. Are we looking to balance that out? Because if we don't, we're going to keep losing members, which is a problem. So maybe just commentary from the Minister or anybody else. As I said, I'm concerned about the loss of staff due to age and retirement, the loss of staff due to not having our intakes match there, and then prospectively impact on staff due to lack of trauma counseling and proactive engagement. I don't think that just having bulk sessions, but our members do work in a highly stressful, high trauma space, and mental health is a concern. And I do think it's important that we focus on that. Thank you very much, Chair.
Thank you. That was the only hand. Minister, Additional Commissioner.
My hand is up.
Where? I don't see it. Okay. Come in, Honorable Ter Blanche, followed by, now your hand is up.
Thank you, Chairperson. May I go ahead?
Yeah, go ahead. You'll be followed by Honorable Marekwa.
Chairperson, thank you very much. And let me also start by thanking the police for this presentation. It is quite informative, and it's good to go through the stuff that I'm very much aware of. Chairperson, I'm going to start, with the structure, and I just want to know from General Arabi, I see that the consultation is to a large extent or mainly focused on the police itself, like the generals and the unions, and I don't know what else. My concern in this regard is, there is, the trust in the police, the community trust in the police is at a very low, let's say just about at an all-time low, 23%. It was the other day. And my question is, are they going to consult the community to determine what is this that the community is expecting, and how do they plan then to bring that also, to consolidate or, also accommodate this in the structure? That is my first question. Chairperson, the second question is about the death rate, the high death rate amongst police officials. And my question is, have they determined or managed to determine the reasons for this death rate? And I know there a lot was mentioned already, but my concern is it a matter of a lack of training, or what is the position? I just want to get clarity on that. Chairperson, then the early retirement. What worries me, is, are they or have they determined the reasons for this early retirement? What is quite concerning. People are retiring early and they leave on early retirement. and what else? And then, we start immediately then trying to recruit them again. Isn't it maybe better to try to keep these people within the service, because you have paid them out now, high amounts, and then you must bring these people back again. Chairperson, I'm moving on. I'm just about done. My concern is, and we've seen the different, allowances that people are getting. And we know that, the police are staying, in dilapidated buildings like single quarters, houses and stuff like that. And my question is, what is the possibility? I see that they are paid the housing allowance also. And then I know, and I want to know whether that is still separate. People can also, when they buy a house, they can get a housing subsidy. Now, my question is, wouldn't it be better maybe to consider a housing allowance across the board, that people will be able to cater for their own housing, and obviously maybe in the event will be better sort of accommodated and, out of shacks. Then my last question, Chairperson, is the question of promotions. And yes, I know that people need to apply above the rank of a captain. My question is, what happened to promotion exams? That will allow people to, to progress maybe quicker, but that will also capacitate, people better and, obviously, that allowing them to do a better job. That is my questions for now, Chairperson. Thank you so much.
Thank you, Honorable Terplanch, Honorable Marekwa.
Thank you, Chairperson, and good afternoon. Chairperson, let me welcome and appreciate the report this afternoon from the SAPS. Let me also want to start on the issue around pension benefits. We know that pension payout whatsoever, they are regulated by law. But what one maybe want to advise or check with SAPS in terms of way going forward, in terms of the pensions that members are contributing. We know that public service employees contribute to GPF, which also invest in PIC. What will be the role or engagement? Is there possibility of engaging with the PIC in ensuring that as they invest in other areas or all over the country, and so what is it that can be done to make sure that PIC also invest in the employees, SAPS and also government employees, in ensuring that they are able to get proper housing? It can be things that the SAPS can engage on, proper housing for members, because as much as SAPS is trying to do their part, but most of the members not having spaces or houses to live in, afford in terms of affordability becomes also a problem, particularly for those young members within the SAPS. So maybe it will be just my advice to say that let's SAPS look into those issues and so on. So the other one, Chairperson, is the issue on the death grant. I think that one would like to appreciate and also welcome the staggering part of it, because as we know, sergeants are the people that are known. Even when you are on the beat, people, whether you grow up in your rank, they will remember you as a sergeant, because you are the person they've always known to be on the ground. So we appreciate, one wants to appreciate that staggering part, because they are actually the ones who are also exposed out there in terms of danger and so on. The other one, Chair, is the scarce skills allowances. As much as one appreciates the developments in terms of payments or allowances given to those with the scarce skills, it is also equally important to encourage also SAPS to look into other areas, including departments within the country, like your correctional services, to ensure that the benchmarking happens. Because if that area is not going to be tied up, I know that the more you recruit professionals and good quality people with good and quality skills. The other areas are also trying to poach from yourself because it's a competition out there. So I think the benchmarking with the other departments will also assist in terms of making sure that they at least stay longer within SAPS. The other one on progression, I'm okay so far with it, Chairperson. And then the health and wellness, one also wants to appreciate it as much as you know that some professional people will leave from time to time going to greener pastures and so on. One appreciates it, but I want to check. There used to be, I think it happened once, a fun day for police. We know that we commemorate Police Day annually, where we remember those who have lost their lives in the line of duty. But what do we do for those who are still there? We know that the minister emphasized the stomach, the gym, that they must go to the gym and so on, stomach in, chest out issues. But what do we do to make sure that they have a day where they can really be themselves and feel appreciated? And so I think that area at some stage motivated the police a lot. And then, yeah, that is basically that my input, Chairperson, but we appreciate the work that the police is doing so far, but motivating them and maintaining what they have, especially the when we invest on human resource, the companies goes a long way. But I think they are doing their best to ensure that they deal with those issues. Thank you so much, Chairperson.
Thank you, Honorable Mareko. Honorable Gomba.
Thank you very much, Honorable Chair. Honorable Chair, I would like to engage or submit into the issue of the panel itself.
Honorable Gomba.
Yes, Honorable Chair. You're not there yet.
Not there yet.
Okay.
We'll come back to it.
Let me withdraw because I'm just from the flight, so I prepared my notes for that part. Thank you.
Okay, thank you. We'll come back to that. Okay, those are questions and engagements and appreciations. Honorable Minister.
Just one point, Chair.
Yeah, Honorable Mareko. I see Honorable Gerike now. Honorable Mareko.
No, thank you, Chair. It's because I'm working towards the transport. I'm working outside. The one point that I wanted to mention, Chair, it's on PolMed, the medical aid scheme. It's a very good medical scheme for years. Has been the best. But the only challenge of late is the annual increase that some members, when you meet them, they are complaining about it, to say that as much as it does the best, but the annual increase becomes a challenge for those who cannot afford. Thank you, Chair.
Thank you, Honorable Gerike.
Chair, yeah, thank you. Thank you to the General, the National Commissioner also. I've lost a great deal of this presentation due to load shedding where I am, but I have heard something about the promotions. I just want to express a sentiment, if you allow me, and maybe just to hear the other side. On the issue of promotions, I commend the Minister for his preamble this morning to say we are striving towards a professional police force that can live up to the standards of professionality and ethics and so on. But on the issue of promotion, the sentiment from our side is that we must be very careful when it comes to promoting and the criteria for promotion and so on. I know that you have your own system, but we must take into consideration our historical context, where we're coming from and where we want to go and take this country. Many of our members in the police force are not on that high standard as yet, but it doesn't mean that we must create barriers not to promote them or make it difficult for them to graduate to the next level. We must work out some kind of a system that can assist those members that serve diligently in the force through our years. But in some instances, they are, just not academically so good, but practically they work hard, they are diligent, they are committed to the service and so on. I'm just trying to say we must strike a balance to create some kind of environment where we bring those people up also in the knowledge where they can empower themselves and so on, without making it difficult for those members that served many years in the service, but they cannot progress to the next level. That's all I'm saying, Chair. Thank you very much indeed. And therefore, I ask that there must be mitigating circumstances. We are not a first world country, Mr. Comrade Minister. We are not a first world country with first world standards. We must take into consideration the historical context of where we're coming from. The emphasis is on where we're coming from, how we have been held back in terms of opportunities. But we must make sure that our people have got the relevant educational qualifications going forward, and therefore the department must assist them at all costs. Thank you, sir.
Thank you very much for your contributions, honorable members. Honorable Minister.
Chair, I would request from your permission that the National Commissioner goes first on those administrative issues.
National Commissioner.
Thanks, Honorable Chairperson. Starting with the retirement age of 60 instead of 65, as the Minister alluded to, yeah, we think of certain sectors of our police service, especially who are specialized, if we can in future allow them to get to the age of 65. That's why what we'll start endeavors to move in that direction. However, why the age 60 instead of 65? Well, this is worldwide that policing is a very, very stressful job. And hence the occupational loading for this type of work is so much that the age 60 is preferred. Some countries actually are far below what we are, 60. Some countries are 55. Some countries are at the age of 50. So we are still at the age of 60. So it's based on what goes into the people so that they do not stay longer, because if they stay too long, by the time they finish, is wear and tear. So that's why that's the reason why the age is like that. But we agree that certain categories can be allowed to move beyond the age of 60. Honorable Tereblanche on the consultation on the structure. Normally we consult the social partners and internally, and that is it. I'm not sure if we go out, how long it's going to take us, but that can be discussed. We'll discuss it with within the executive and make a decision on that. The issue around police killings, yeah, it's quite a number of our members that die on duty, and we do all we can. We have a police safety strategy that is out there that we do implement with a view to take care of them while they are at work at the police station. Secondly, making sure they've got the right tools when they are at their work, including the training that we are giving them. What we're doing is to make sure that we do the refresher training as quite often as possible and improve more in that line, because we have seen that there is a room for improvement in that regard. And yeah, that's why we are doing the retraining of our members with a view to reduce this police killings. Is something that is out there, Honorable Chair, is a challenge that we have. Just a day before yesterday, there was, I think Monday, there was a CIT in Bloemfontein, and there was a chase between police and those criminals, and we caught 6 of them, all of them coming from Gauteng, and in possession of 3 AK-47s loaded, 1 R5 loaded, and the Uzi automatic pistol loaded. So it was fortunate the way they were caught, they never had the chance to shoot. Just imagine if there was an exchange. So those are the situations that we meet out there that requires our members to be ready all the time, and they need to practice. That's why we emphasize that they be taken for practice and be ready for the fight out there. On the matter of early retirement, I think it was Honorable Blanche that raised on the early retirement. Most of our members that takes early retirement are at the age of, majority are over the age of, they are 56, 57, 58. So in other words, it's those category of members that do not want to go on pension, they want to cash out on their pensions. But yes, indeed, there are those that resign very young, looking for greener pastures, but the figure there is quite low. Those are the ones that sometimes they find themselves having to come back. But yeah, the early retirements, the figures are much more than the resignations. But yeah, normally at that age, 56, 57, 58, you can't really refuse them if they want to go. General Divert will talk on the issue of housing allowance. I'm aware that all our members, they do get the housing allowance that is standard by all. The only problem of the housing allowance is that those that are staying in the barracks, they end up forfeiting it all, which makes them not like to stay in these barracks, which we said we need to look at a different system. Because when we look at other countries, their benefits in terms of housing is a bit different to ours. There are other countries, their housing allowance is quite much more accommodative of the members, which enable the rotation of police officials much more easier, which in our case, it is not assisting us in terms of rotation, because the first thing we have to worry about is the housing in the area where these members are being sent to. So I've tasked the HR to study that and benchmark it with a number of countries so that we can come back and make a proposal to various bodies, including this committee, with a view to see if we can have a better benefits in terms of housing allowance than what we have currently, which is not much assisting to the type of environment that our members are working in. On the issue of Polmet, Honorable Marekwa, yes, Polmet is the best currently, but yeah, we take note of the increase that is currently there. I myself did speak to the board of Polmet about that the increase, they should look at it. It seems to be coming regular to the pocket of our members. Well, of course, but I think everybody's now going into, looks like, into NHI, including us. In terms of skills, scarce skills allowance, we do benchmarkings, yes. It's just that we don't have OSD, and I think the Department of Correctional Service, they do have OSD in certain category of their environment. But I think in terms of the skills allowance, we are still a bit much more better than them. We did look at their benefits. I think they are better off in areas of your certain allowances, but their on skill allowance, I think we are better than them there on. And under Mareko, a day to be given to the police. Currently we do have the National Police Day, which was proclaimed by the cabinet, which is December. I mean, it's January 27 every year, where we do give the police a day. We are considering a fitness day, maybe half a day, where we would do a massive fitness assessments nationally, so that we still looking at the details. Maybe we can come up with a way forward in that regard. General Divide and your colleagues, can you come up with, can you answer some of the questions, including the promotional exams? All other questions?
Thank you, Chair. If I can continue. I think the issue that was raised by General Masimbola with regard to the legislative part, yes, the legislation say that we have to retire at age 60 and the public servants at 65, but we're also aware that in other countries they look to increase the retirement age, but it's in those countries where there's not a real growth as far as population is concerned. Also, what we have to take into consideration is that, like I've indicated earlier, that 87% of our people are performing production work. And if we think of our policing officials, the majority of them are basically performing visible policing function in some way or the other, and also in protection and security services, which is basically about 60 to 70% of the people that we have that is performing operational duties. Now, you need to keep them fit and slim and healthy all at once, and we know that we all have some bad habits that we're trying to manage, and EHW has got their hands full as far as that is concerned, and that's also why we touched on some of the programs, but it's not always successful. You know, we continue to find our people, you know, having a pie and a Coke somewhere when they have a break for lunch or something like that. So our eating habits are not always talking to our operational habits that we need to have. Also, our operational commanders has communicated with us a lot of the time to say that, you know, when the people are over the age of 50, 55, they are struggling to perform those very active policing functions and would like to be in the CEC and at the courts and those type of things, and we have to take cognizance of that. There is initiatives in order to improve our fitness, but typically at the end of the day, as the National Commissioner also indicated, the life expectancy of people doing the policing functions are less than other people, and as a result of that, you know, we still want to make sure that they have a healthy retirement going forward. Also, when we're looking at, for instance, our attrition rates, I think we need to be honest and say that with all the cost cuts, at some point in time, SAPS would have to reduce their numbers from 190,000 to 163,000. That was what was communicated to us by Treasury, and for 2 years we had to only live with attritions. We couldn't really recruit people, even though here and there we have succeeded in recruiting reservists. We have filled certain posts that we advertised externally and so forth. And as a result of that, that's the reason why the figures are not looking so rosy when we are comparing the number of exits with the number of people that we have employed. Over the last 2 years, we have, by the grace of the President and the Minister, we have been recruiting 10,000 at a time. But if we then compare the number of people that we lose, which is around about 6,300, 6,400 with the 10,000 that we are employing, we see that we have a growth of around 3,600, and we slowly but surely we are turning the tide in terms of making sure that we moving to a balanced approach as far as policing is concerned as well. Also, there is other initiatives that the Minister spoke about, like, for instance, your re-enlistments of specifically target groups, which includes your detectives. It also includes other skill environments as well. So there is things that we are doing in order to try to do that. But for the last 4 of the last 6 years, we were not in a position to grow the organization at all, and we have to take cognizance of that as well. Also, when we're looking at people taking early retirement, at least between 67 to 70% of our people that take early retirement is at the level of warrant officer and captain, which basically means it's those kind of people that I've touched on that have been in the organization for a very long period of time and believe that they have run their course as far as that is concerned. And also, people that achieves, the retirement age. If we look, for instance, at the figures of early retirement that we have communicated to you, when people look, for instance, at early retirement, I saw in 2021 a huge number of people that went on early retirement. That is because there was a specific drive by government in order to reduce people in the public service. And as a result of that, that is the reason why that there was such a high number. Then also what we have to keep in mind when we're looking at retirement, in the early 2000s and around about the time that we have had the Soccer World Cup, there was also huge recruitment drives. And a lot of those people are now maturing in these age brackets and so forth. So you will find that there is reasoning behind it. And as I've indicated, we are having quarterly meetings in order to look at where we are losing people, in which areas, which levels, etc., so that ultimately at the end of the day we can find and put solutions into place. But what curbed us was typically, the fact that we couldn't recruit people and replace people for a period of time. Luckily, at this point in time, we are still allowed to recruit the 10,000. We will see what the treasury allocation is for the next year. That will influence in terms of what numbers we are allowed to recruit and how quickly we can turn that specific tide around. When we're looking at housing, I think there has been a lot said in terms of that. Obviously, there are certain recommendations that has been put forward as well. But SAPS are encouraging people to own their own homes. And that is the reason you will find that if you are buying your own place, you'll probably earn more of an allowance than if you are just renting and so forth. So that there's also that difference that takes place, and it's also a generic benefit that is available. The proposal by Honourable Marekwa with regard to the PCBC, the police engaging with the PIC, which is the investment body of the GPF. An initiative at the PCBC has been initiated to engage with the PIC in order to see how they can assist public servants, not only police officials, but public service in acquiring housing and obviously improving their plight as far as that is concerned. Also, the issue that was raised with regard to we need to look after people that don't have qualifications, because it seems to people that if you don't have a qualification, the higher ranks is not for you. That is not the case. We have a two-stream approach. Those that have qualifications and those that only have matric and years of service. So if you don't have a qualification, you have to at least serve 4 years on that level before you can apply for the next higher position. That's typically focused at our policing jobs. But if you want to become, like for instance, a professional, you have to make sure that you have the relevant qualifications, register, and make sure that you look after your professional status. So there is definitely things that we do as far as that is concerned. We also have a bursary scheme that people can apply for based on their interest. But also, we also afford people study leave to allow for that to happen. And there is also an amount that gets paid to a person once that person has successfully acquired that qualification. So there is specific things that is focused. There was also issues raised with regard to health and health screening and those type of things. We can say that we are encouraging fun days. Obviously, it cannot be every day, but there is opportunities that we allow for our people at the end of the year during Easter and so forth, in order to have specific days that they can they can relax and do things. We have on a Wednesday, we have our sports day that people can access if the operational requirements allow for that to happen. And then we also have health screening weeks where, for instance, the health professionals are available, and during that specific week, people from a specific designated area can then access those professionals to be able to check their blood levels, they can check their glucose, they can check all of these type of things, and we are encouraging to do it. And it doesn't only happen once every year in a specific area. I think it happens more than once. Also, we have our annual fitness assessment that needs to take place, which also identifies certain areas. And we normally coincide our fitness assessment with these health screening weeks in order to make sure that these things talk to one another and that we can find our way forward as far as those things are concerned. As far as Palmet is concerned, I think the issue that was raised is valid. However, we must understand that economically we are struggling as a country, and then also that medical inflation is running away. I think we're looking at up to 16% medical inflation during the last year or so. So the Palmet, like the General has indicated, has been sensitized, and they're trying to see by looking at different benefits within Palmet where certain savings can be made and which of the benefits that a member qualifies for should be prioritized above other. They have initiated specific designated service providers that will allow people to access services at a cheaper rate, which should obviously prolong the use of the benefits and so forth for our members. I think that's it from my side, unless there is a specific area that you would like me to touch on. Chair, I think I've covered the majority of the issues. Thank you.
There's a question on promotional exams. Additional Commissioner.
General Divet, currently, Honorable Chair, we, as members write and acquire various qualifications, they do not get promoted automatically. We do advertise posts, and then from that level of captain upwards, they apply, and then the qualification adds to their advantage, and then members get promoted, but depend on availability of posts. Not that everybody with qualification is eligible for promotion. And of course, we directed that the HRM, together with the unions, we need to finalize a promotional policy that will deal with those matters. I don't know whether General Divide with anything to add there.
Thank you, General. I think you've made all the points. I think sometimes people think that people just get promoted and then they don't have to obtain the requisite skills to be able to perform those functions. That doesn't happen. We have proactive management processes where people have been identified to go through. We have your senior executive program, you have your middle management program, you have your station commanders course, you have your commanders courses, etc. All of those things are available to people within the relevant areas of their expertise. I'm just naming a few. The point that ultimately at the end of the day that people believe that you need to go and acquire a specific qualification or a specific exam in order to progress. I think we have looked into that in the organization, and it's typically something that you've touched on, that if it is viable, it should be reflected within our promotion policy. If it is not viable, then we need to be able to find a way and in identifying where we need to build in those hurdles that will allow us in order to come up with those areas so that we can develop them, so that there is additional criteria apart from suitability, experience, and skills in the job that will make you suitable. Thank you, Chair.
Thank you, Honorable Golding.
Thank you, Chairperson. Just the one that I think I got a bit of feedback on was in terms of engagement around trauma, and do we think those numbers did seem a bit low. Just one follow-up question. I know there was an allowance for uniforms, which was at an annual level. I'm just trying to understand whether what equipment that covers, because I've got to assume, does that cover stuff like boots? Are the inspections done around these things if they need to be replaced? If I look at gear such as bulletproof vests, if they still fit, obviously that can't be purchased, that is issued. What is the process run ensuring that the PPE in effect is current and effective? I'm assuming boots form part of uniform, but 1,000 Rand would buy one pair of boots for the year. I'm just trying to understand that the members are safe and comfortable. And then, of course, just the question around trauma. Thank you.
National Commissioner.
Thanks, Honorable Chairperson and members. We do give members a credit for a clothing credit, which they use to buy uniform. It only is used for buying uniform, excluding your PPEs. PPEs are being taken care of separately, including your bulletproof vest. It's not part of the clothing credit. The clothing credit is solely for uniform, and of course with detectives, and solely for use to purchase their private clothes. Detectives can purchase 100%, meaning they can use the total credit, be 1,600 to purchase. But we are aware that there is no suit that you can purchase that costs 1,600. Hence, we were in the process to increase the allowance now when the austerity measures came into being. We wanted to increase the allowance and also review the prices of the uniform clothing for uniform members with a view to establish some uniform packages where members can be able to, the lower the rank, they can be able to purchase quite a number of uniform with a devalued amount on the uniform. So, but that was not, we were not able to implement that because of the current financial position which we find ourselves in. But with the uniform one, we think we will still be able to try our best. Thanks, Honorable Chair.
Chair, maybe I can respond on the
trauma. Yes.
Sorry, Chair. Sorry. The issue raised by Honorable Golding with regard to the trauma debriefing. Short answer, we are implementing the national instruction that is making trauma debriefing compulsory. And then obviously we have indicated that we have people that can debrief them, or if those people are not available, Format will provide the service on behalf of the organization. Thank you, Chair.
Thanks very much. Minister, do you want to comment?
Well, Chair, almost all answers I can just be generic. Chair, we are really trying to make this the organization of excellence, even on the recruitment. We are recruiting on the specialized way. Yes, our laboratories are receiving a lot of BScs, and we are recruiting many people that have done law, psychologists, to be able to work on those particular matters. Chairperson, the question of debriefing, I want to emphasize that all the research points on the very mentally depressed nation. Is not just for the police. They say after COVID-19, almost that is a very prevalent kind of disease, the mental disease at the present moment. Maybe that's why that even the nation has become so violent. Chair. Things like rape, Chair. You will be giving this, and as we'll be giving again these statistics. Almost numbers are increasing of people that are raped in their own houses by the people that are supposed to be protecting them. And you can realize the brutality. You've seen 3 days matter that happened in the mine and all that kind of thing. It's quite a hell of depression, national depression. Police are part of this. Nation. Maybe it also answers the question asked by the member of vis-a-vis 60 years, but also a highly depressed and a high intensity kind of job they do. Police, if there is any depression and highly intensity of job they do, is doubled with the police. But Chair, we have spoken to the police. We have invited the management and the ministry, invited them to find out what are the reasons of them leaving early. Basically, they will simply say they are tired. Others are quite sickly, and others, they don't see their opportunities growing in the police. That is what we're trying to work on, to say in this organization, the well-being and welfare must be really worked on. There are issues that we're dealing with maybe at the present moment. As we finalize those kind of things, we can be bringing them. One thing that we are looking at, Chair, we can't have the army of generals. Everybody can't be general brigadier. So if can we find a way of those best that can be promoted because there are no position, where work on their financial up ladder, maybe grow financially within the organization, even if you don't grow in terms of the rank. We know police love two things: they love their ranks, they love their financial benefits, like all of us. But working on those things within constraint that we have. The member asked the question of those that could not have received opportunities of growing. I think the National Commissioner has answered on that, but there is a special category of people that were non-statutory that were put in this organization. Unfortunately, that matter is staying in court forever, Honorable Member. Including a week or two ago, there was supposed to be a decision by the Court of Law, since some civil organizations have taken the decision of their promotion to court, and the judge now is not deciding. So we're trying to write to the people responsible to that. Can you give us the judgment of those people that they come from the non-statutory, so that they are fully integrated on the matter. On the question of communities, indeed, we can really go and consult every structure of the community, but you will also know that there are constitutional structures that now and again will be dealing with them, like CPFs. I could simply say, even at that front, we have really tried to make those structures functional, Honorable Chair. As you know, that we budgeted 70 million. I was very happy 2 weeks ago when I was in Eisentswelenge Stadium in Randfontein, where the Gauteng gave 17 of Kumbis to the CPFs to be able to do their work without the hindrance of any form of restriction from the management and all that. So that is to encourage that the communities work with the police. It can't be really everybody, but especially taking care of those structures that are constitutionally and legislatively given to us to work with. We're trying hard to do on that. Maybe to round this one up, Chair, if it were according to us, Ministry and Management, our police should be really getting much better. We once tried. For instance, we were trying to say from a certain level, I think it was 11 down, if those cannot be taxed in the organization, and well, Treasurer and SAPS could not agree on that, trying to improve on their lives and on their home take. As you can see that when you go to Constable and the Real Sergeant, the home take is pretty low. Working on those matters, Unfortunately, that will be forever collective through the DPSA and other structures. Treasurer, it's out of our hands as per this organization. As we say, we would have loved to do better for our members. There is this, I don't know where it comes from, this thing that our members, they are killed because they are not well trained. They are killed because we've got a criminal mind nation, not because members are not trained. They're criminal members. 2 weeks or 3 weeks ago, I buried a member of the NIU chairperson. You're not going to tell me that if you know the structures of the South African police, you're not going to tell me that NIU is not trained. For that person to die, which means those criminals are determined and they have their criminal mind to make sure that they kill the police. It does put us on a little bit back foot to say they are not trained, and then it seems to give some morale to the criminals to understand that they are doing this thing because the onus is with the police, and I agree, is with the police. But if you can make a lot of shout against the criminal-minded nation, chairperson with criminals, as the commissioner was giving you the story of Free State that happened yesterday. We have got criminals that they plan to go and do things, serious things like cash us and all those, and they don't carry broomsticks. Those people, they don't carry feather dust, and in their planning is to eliminate everybody or anybody that stand on their way. And most of the time, those people that stand on their way are members of the South African police. So it's not as if it's by chance that members of the South African police are killed. It's by design of the criminal mind. Hence, they are trained. Hence, the members that face those people, they are ready for that. Most of the time, when there is an engagement with the criminals, we win. Members of the South African police win. But the members will be found on those compromised positions if they do the work alone and all that, go home driving, and when they're on duty like that. And especially, there is a new trend that those that are doing well in investigations, they are killed, as it happened on N1 a few weeks ago, of our members, even of Hawks, who are doing very sensitive cases. So it's something that looks like we are facing, and it's something that we are working on. It is something that we'll have to win at a certain given time. But for now, is a criminal mind. It's not because police are not trained. It's a criminal. We have a very criminal-minded nation in South Africa at the present moment. Chair, we would love to keep our members rather than re-inviting them back, but we love, especially on the on-field gained experience, like investigations, like detectives, we love. So if they have gone for some other reason and we really need them, we try to keep them and we try to extend them, but we would not stop, invite them back to enhance and make sure that the organization is functional maximally. One would thank the members that has acknowledged that there is a progression, there are things that are done, but also thank the members that have made the contribution of the areas where more improvements can be done. Thank you very much, Chairperson.
Thank you very much, Minister. I know that, and thank you for the comprehensive presentation, National Commissioner. You said you are still consulting on the organizational structure. We hope after completing your consultation, you still come back to the committee and brief the committee. But as you consult, and you don't need to respond now, as you consult on your structure, I see on what you proposed as an ideal structure is the structure towards which you want to move. I see you are trying to put component head compensation services under the CFO. You are putting strategic management under the CFO, organizational development under the CFO. Maybe there's a rationale. I'm just saying, if you keep it like that, come and brief the committee with a rationale, because I would imagine that strategic management should be in the accounting officer's office, which is the national commissioner, because it's the accounting officer that drives the strategy of the organization. Organizational development, this one is a purely HR matter. Compensation is an HR matter. The chief financial officer presses the button after the HR manager or corporate services manager has prepared the compensation, the report on compensation of employees. Those are the issues that I'm saying, look at them. I know you're still consulting. Look at them. You don't need to respond now. But when you consider them, because the CFO, I think we're jealous about the position of the CFO, who's in the main, the advisor to the accounting officer with regard to management of finances. So you don't want to burden that person with other issues that are not core to the finances. And these ones that I've mentioned, I think is common practice across that they are core to the HR division. But thanks very much. You can look at that, and when you come back, you'll tell us what is it. Thanks very much for your presentation. Thanks very much, Minister, National Commissioner, Deputy Minister, and your team for the presentation. The last thing before we close is a feedback from the Secretariat on the assignment given earlier, so that we finalize on that one. Secretary.
Thanks, Chairperson. Advocate Bell will read our submission. Advocate Bell, through you, Chairperson.
Thank you, Chair. So we have considered the proposal to expand the provisions of the composition of the panel to assist the Minister in the appointment of the ED. However, it is submitted that the department reiterates that this position will offend the legal framework with respect to the appointment of the head of the national department as enunciated in the Public Service Act, the Public Service Regulations, and the Executive Protocol for such appointments. Our submission is that the provision as contained in clause 4 sub 1 is indeed consistent with the government procedures in appointment of heads of departments, and in this instance the appointment of the ED is adequately insulated against political interference as pronounced in the Concord in the McBride matter. The proposal to expand the panel is therefore not supported. Thanks, Chair.
Thank you very much. The comments from members, Honorable Golding, Honorable Whitfield. I know Honorable Gomba wanted to comment. I stopped her. Honorable Golding.
Okay, Chair, I'm kind of confused. Mr. Simbalani or Samani earlier on indicated that there wasn't an issue, that they were going to go back and adjust the wording, which was a compromise point of view. What has happened is Advocate Bell's come back with the legal opinion. That's not what I assumed we were going to get. I assumed we were going to get a recommendation in terms of the wording change. So I'm a little bit confused at this point. I am expecting an alteration in terms of wording. I'm not expecting a reverse opinion as opposed to Mr. Atsamani's input early on. Thank you, Chair.
Honorable Whitfield, followed by Honorable Masuku.
Well, thank you very much. Thank you very much, Chairperson. I must say that the feedback is noted, but it's largely irrelevant. The Civilian Secretariat reports to the Minister, and Parliament's job is to legislate. And while this is an executive bill, when it was sent to Parliament, it was sent in an unconstitutional format. And the committee has attempted to rectify that. But as I pointed out in Parliament last night, that the deliberate exclusion of this section that gives provision for parliamentary oversight in the original draft of this was a failure of the Civilian Secretariat and the Cabinet and the Minister to send us an unconstitutional bill. And it demonstrates the intent, which is to undermine Parliament, to not take Parliament's role seriously, and to now try to rectify it after the fact by allowing Parliament to do so. We've been shown exactly what the Minister and Cabinet think of Parliament's role. We have inserted the bare minimum back into the bill, which is in the Principal Act. And I believe that the bare minimum is insufficient now that we know that the very clear intent is simply to use Parliament as a rubber stamp, as it was in the previous process. So respectfully, I would repeat that there is no lawful legislative impediment for Parliament to amend this section of the Act. We had, I thought, and based on your comments, which can be taken from the recording, we can hear that we were moving towards a compromise position. Civilian Secretariat's views are noted, but from my perspective, they are rejected. We have a duty to strengthen this bill, not simply to rubber stamp what the executive has sent us. And I accept that we have rectified the bare minimum provision for parliamentary oversight, but it remains completely insufficient if the committee is not going to apply its own mind to the legislative process, which is our function as members of Parliament. Thank you.
Honorable Masuku.
No, thanks, Chair. And apologies for last time not joining, and also for today. I'm actually out of the country and in different time zones, so I mess up myself, and I just want to apologize to members for that. Chair, on receiving this submission, I know that this is my first time in the committee. I had the same feeling that maybe we haven't strengthened enough in terms of what we should do as members to oversight. And I had written comprehensive input that I wanted to send. But on review, I then check what is it that it's intended here. There are two functions. There's executive function and execution function. There's oversight. And when we do our oversight, it depends on what you want to get as an outcome of a particular process. Is it oversighting the process, or is oversighting the product? So when this process goes, any process that we are coming out with, and we have got an outcome of an appointee, are we looking at evaluating the processes followed, or we are required to look at whatever process that we have followed, but is this person fit for purpose? Or are we going to be rejecting on the basis of the processes, or rejecting the fitness of this person? So I realized that ours is to look at this person, whatever you have done, whatever you have gone through, this person, is it right? I thought that that is an outcome. And I just thought that on the basis of that, I might have been wrong, and then I think the recommendations are actually covering that, because at the end we'll be able to say that. Because if we go beyond that, Chairperson, what it means is that we'll then have to stipulate in the act, okay, what criterion that you're going to use to be able to reject the process. And I think that is not the task that we're supposed to be doing. Ours is to whether the minister has done the right thing, he has appointed the right person, and I think that is the end point. Any change that doesn't give us that is just an exercise. It's just an exercise, because it then now become a principle of anticipation. So we're becoming preemptive. We've already charged that the minister will never, ever carry out his task of executing what we have mandated him to do, and therefore we must stipulate nitty-gritties in it, and I don't think that's what the process intended to. The outcome, as is say, it will allow us to exercise our role to say, Minister, we see whatever you've done, this person is not fit on the following basis of how we understand the incumbent of this position to be. And that's how the law allow us to do. And I now suggest that I think the advice that they're giving us is sound on those bases. Thanks.
Thank you very much, Honorable Masuku. Once more, you're welcome, and at least you've seen your face. Honorable Gomba.
Thank you very much, Honorable Chair. My view, Honorable Chair, and this is what I wish to see happening, that I support that we retain the composition of the panel as prescribed by the public service regulations, Honorable Chair. And also the regulations are applied by all government departments. Honorable Chair, also, I think my argument is still the same, that there is sufficient checks and balances in the bill to ensure the independence of the IPID. Honorable Chair, again, I would like to indicate that the Constitutional Court in the McBride judgment did not pronounce on section 6, 1 and 2. That's my input, Honorable Chair. Thank you very much.
Thank you, Honorable Gomba. Honorable Gerike.
Thank you, Chairperson. Chair, we take note of these sections as has been read out by the legal department. We are also in agreement that you cannot just upfront taint the reputation of the minister or his executive, or vilify the minister in the role that he has to play. We cannot show prejudice and bias to surmise that the minister will appoint cronies and so on. You cannot do that. However, if the sections read by the legal department meet the requirements of the Constitution, we will support it. But in our understanding, we struggle with the issue of independence. If you have in that sections of the Public Service Act, 2 members of the executive that must also be part of that committee, we struggle to draw a line between independence and the executive. That is the problem here which we are facing. But on all the other issues, we don't have a problem. So we have a problem with the independence. And again, as I also have said last night in Parliament, in the plenary, that we must consider the separation of powers in order to secure the independence. This is what it's all about, the independence. Thank you so much, Chairperson.
Thank you, Honorable Gerike. Honorable Golding.
Thank you, Chair. I'm a little bit confused because in the earlier portion of the meeting, and Mr. Sermani indicated that it was doable. We actually even had the assent of the minister. We're not dictating to the minister who he appoints. The aim was to ensure freedom and fairness by appointing more people and to make it more transparent. As to what that wording was going to be, to expand it, is what the Secretariat was going to come back with. We're not prescribing who is specifically chosen. And in terms of the executive protocol as stated, and if we read that wording, it says may at least appoint, which seems to be a minimum guideline. No, it's not prescriptive. If it was prescriptive, it would say 2 and only 2 and 1 and only 1. So it does not limit that. I'm very concerned by this. Chairperson, if we do not get resolution on this, I'm going to request that the specific item gets held over. We can cover it on Friday if need be. I'm thinking that the DA needs to reserve its rights. We're going to request at least some external legal counsel from our side on this, because I don't buy into the interpretation of the Secretariat on this. This is not as stated earlier on. We were a hair's breadth away from resolution on this matter, and now it's all up in the air again. And that's not what was committed to this committee by the Secretariat to come back with. They were going to bring us a wording change. So, Chair, I ask that you offer guidance on this, but I'm concerned. Thank you.
Thank you very much. Honorable members, in terms of inputs, I think majority, Honorable Gomba, is this an old hand?
Yes, excuse me, I'll remove the hand, Honorable Chair. Thank you. Sorry.
Thank you. In terms of the inputs, it seems the majority of members support the view as presented by the Secretariat. Of course, there are members who are reserving their rights, and they wish to have an opportunity to get an independent legal opinion. And I think I would be correct in my summary to say, for now, there is sufficient consensus that we go along with what was presented by the Secretariat. But if there is I think even the Minister promised that he will go and consult with the Minister of Public Service and Administration to check the implications. DA is committing that they are going to have a legal opinion. So until we get a different view, this will be the decision of the committee that goes along with the presentation by the Secretariat in terms of majority of members supporting that. This will be sufficient consensus. I think that's how I will summarize it, members. And then if something to the contrary happens, we're still able to review. Honorable Whitfield.
Thanks, Chair. Just in terms of procedure, where to from here? Are you putting the clause by clause to a vote now, or how do you suggest that we proceed? Because there can't be consensus if it's still up in the air and things may change. So there's either consensus and we put this behind us, or we leave it up in the air. It's one or the other. Just to be clear, thank you.
No, we don't leave it up in the air. I said in terms of inputs, there seem to be majority of members supporting the view as presented by Secretariat. That is a vote, unless if you want us to vote by show of hands.
I'm simply inquiring as to the procedure. You're the chairperson. I presume you've had advice on how to proceed technically with each of these meetings.
Yes. Thank you, Honorable Whitfield. That's why I said, in terms of how members contributed, there seemed to be sufficient consensus, not complete consensus, but there seemed to be sufficient consensus that we go along, the committee goes along with the presentation by the Secretariat. However, there's a submission that there'll be a legal, some members will go and seek for legal opinion, and then we'll cross the bridge when we arrive there. But for now, this is the resolution. Honorable Gerige.
Yeah, Chairperson, there's no objection to your ruling. All I'm asking is that as we have articulated in this meeting on this particular point, that our articulation be written into the minutes, even though you are expecting, a legal opinion from either the DA or whoever, but let that position be written into the minutes. Can I ask the Chairperson?
Yes. All contributions by members should be captured in the minutes, which contributions lead to a resolution. The minutes will also capture the resolution of the committee. Members, you still want to debate? Honorable Gomba?
Chair, no, I wanted to support the manner in which you are summarizing the resolution, that it needs to be actually recorded on the minutes as a resolution for this item. Thank you very much, Honorable Chair.
Thank you. Honorable Goldie?
Chairperson, for the sake of minutes as indicated, the Secretariat can check my very specific wording, which I used at that point. I did not say I was going to present a formal legal opinion before this forum. I said we would seek legal advice. And if on our advice, it means we need to get an opinion, you understand the cost implications. I am not the legal person. I will take legal guidance, and based on the legal guidance, come back. But I'm not convinced by the guidance I've received from Advocate Bell, if that is okay, just for the sake of minutes, so that it's not expected for the DA to present you a legal opinion on Friday, if that is fair.
Thank you very much. Can the minutes be captured as such? The minutes must capture the spirit of the meeting, contributions of members to the meeting, and the resolutions of committee. And let me request you, honorable members, when you receive draft minutes well in advance, go through them thoroughly, and where you think something is missing, please raise that so that we are able together to correct that. Honorable Gerige, this is a legacy hand, ne?
Yeah, sorry, I lowered the hand, sorry.
Thank you very much. Having said that, honorable members, thanks very much. Like I said in my opening remarks, we expect, we have submitted an application to have a special meeting on Friday. The minister has requested that we start at 8:30, and then it will be an 1 hour, 30 minutes meeting to allow the minister to brief the committee with regard to crime statistics before the minister briefs the country with regard to the crime statistics for the third quarter. And on the side of the parliamentary legal services, I think in terms of our schedule, you are aware that you are now supposed to prepare the A list, I'm told, which will ultimately become the B list. Let's continue as we agreed. It means we'll engage with this process again next week, Wednesday. But on Friday, we are meeting to receive a briefing from the Minister on crime statistics. Thanks very much, honorable members. Thanks very much, Minister, Deputy Minister, National Commissioner and your team, Acting Secretary and your team. I didn't see the ED, but ED, if you're here, you're welcome, and we want to thank you very much for your contributions. Mr. Simani and your team, we want to thank you for continuing to support the process. It is a difficult process, but will ultimately conquer. Thanks very much. Enjoy the rest of your day.
Thanks, Chair.
Thanks very much to the support.
Thank you,
support
Chairperson.
staff.
Bye-bye.
Thanks, Chair.
Thank you, Honorable Chair.